Bad boy gun. Grand Rising, everybody. Today is Saturday, August the 8th. Welcome to another episode of Operation Wisdom. I can't tell you the numerical value because I don't know. We do these all the time, almost for 2 years now. And I'm so happy for a lot of people that have been here for almost the whole time since the very, very beginning of everything. I think like December of 2024. And we're still crushing. We're still going. Today is going to be a very, very interesting episode. I guess we'll title it Dismissal is Not the End. Okay. Today we're going to be going over my Hood River federal civil lawsuit and the dismissal that was actually issued out by the judge. Very interesting, very interesting, very interesting. We're going to be going over a lot today, but one of the first things I want to start off with today is a video that was done by Clearly Established. This is going to be in his YouTube channel, Clearly Established, and this is a civil rights attorney down in Texas. And one of the things I want to mention in relation to the actual dismissal in and of itself is I want to let everybody know that I have not been working in this case, as far as Hood River is concerned, solely on the merits of just me receiving monetary value. I have utilized this case to try and essentially bring forth the understanding, or at least comprehension, of cops out in the streets that they know that we have the right to travel. All right. Just to give you a little bit, if you don't know, I was literally no plates. I had private traveler plates on, no DOT or anything like that, but private traveler plates, no insurance, no registration, no driver's license, and I literally was let go by the officers. I was arrested and all, but clearly let go. And then also, not only that, but the cops stated, well, yep, I understand you have a right to travel. And I can't call you a sovereign citizen because you actually know your shit, even though I like to be called a sovereign citizen because I do believe that I'm the sovereign citizen of the land. Okay. But either way, we're going to start off and get into this. And I think once you watch this video with us, you're going to understand a little bit more on possibly why my case got dismissed. So let's get into it.
The Supreme Court just released an opinion that I think has pretty interesting implications on qualified immunity. Let's get into it. So the case actually wasn't about qualified immunity. The opinion was actually the Supreme Court refusing to expand a common law defense that judges had invented specific for military contractors. As you know, today, that same court, using the same reasoning, citing similar principles, will protect a police officer who violated your rights using a defense that judges also created or invented. I'm Brandon Grable, Texas civil rights attorney, and this is probably the most important case about qualified immunity that isn't actually about qualified immunity. That opinion had a 6-justice majority written by Clarence Thomas, and he articulated the exact reasoning that should actually collapse qualified immunity yesterday. They just applied it to contractors instead of cops. Let me show you.
The date, November 12th, 2016. Bagram Airfield, Afghanistan. A Veterans Day 5K race is minutes away from starting when Americans, both soldiers and civilian contractors, crossed paths with a suicide bomber.
Split my diaphragm in half and had a lot of shrapnel to my stomach area, which resulted in loss of my large intestines, loss of my small intestines, loss of my colon, loss of my spleen completely.
Ultimately, the blast also cost Specialist Bilyeu her leg. Major Marvin Branch almost lost something much more.
I almost lost my family.
Unfortunately, Julianne Perry was not so lucky.
I was 27 when I became a widow.
Perry's husband, John, was killed in the suicide attack. The father of 2 was one of 3 U.S. soldiers and 2 civilians murdered. A total of 16 U.S. Army soldiers were injured. Several, including those we spoke to, are based out of Fort Hood.
He was killed by a contractor who made a bomb.
The assassin was a local national, contracted by Fluor, a government contractor based in Texas. The government, in its findings, says complacency and lack of supervision by Fluor allowed for the suicide bomber to construct and employ a suicide vest inside the Bagram Airfield perimeter.
How did this guy make a bomb using your tools, your equipment, on your clock, getting paid by you?
The victims and their loved ones filed a federal lawsuit against Fluor. they have many unanswered questions.
I received a 1,000-page, heavily redacted investigation report.
It should be noted the government did not terminate its task order with Fluor, stating in this February 2018 letter, it is not currently in the government's best interest.
They're a machine that just keeps running. They don't care about who gets run over in that process.
You didn't change anything. You're just like, okay, this happened, but so what kind of thing. Let's keep going.
Oh, sounds familiar?
And I don't think that's right.
In 2016, at Bagram Airfield in Afghanistan, then the largest U.S. military base in the country, a Taliban operative named Ahmed Naib walked onto the base carrying a suicide vest. He had been hired through an American military contractor called Fluor Corporation as part of a program called Afghan First, which required contractors to hire Afghan nationals to help stabilize the local economy. Army Specialist Winston Hensley, 20 years old at the time, saw Naib walking towards a Veterans Day 5K race, and he moved to confront him. Naib detonated the vest and 5 people were killed. 17 were wounded. Hensley suffered a fractured skull and brain injuries. So Hensley sued Fluor. The Fourth Circuit Court of Appeals threw the case out. They said there's a doctrine called battlefield preemption, that during wartime, any tort claim against a military contractor operating under its military command is preempted. Full stop. It doesn't matter if the contractor violated its own instructions, you can't sue them because of war. Doesn't matter if the government didn't tell them to do the thing they're being sued over, the lawsuit just can't proceed. And if you're thinking, what the heck? Where did that doctrine come from? Well, good question. It didn't come from Congress and not the Constitution. Judges just made it up and they kept it up. They kept it alive. They kept expanding it. They stretched the 1988 Supreme Court case called Boyle v. United Technologies, which itself created a judge-made defense for government contractors and then expanded it into a blanket immunity for anything that happened in a war zone. On April 22nd, though, the Supreme Court said no. Justice Clarence Thomas wrote the majority opinion, and he was joined by, pay attention to this lineup because it's rare, Sotomayor, Kagan, Gorsuch, Barrett, and Jackson. That's a 6-justice coalition that cuts across every ideological line on the court. And it tells you this isn't a partisan ruling. It's a principled one. So what principle did Justice Thomas articulate? Principle 1, no preemption without text. Quote, there is no federal preemption in vacuo without a constitutional text or a federal statute to assert it. So translation, courts don't get to displace ordinary law just because they feel like there's a federal interest in the area. You need text, constitutional text or a statute. Now hold that thought. Principle 2, judge-made defenses are narrow. Boyle addresses a special circumstance in which the contractor has a defense because the government has directed a contractor to do the very thing that is the subject of the claim. Plain English, a contractor only gets this judge-made defense when the government told them to do the exact thing they're being sued over. So for example, if the government told Fluor to build a suicide bomb, then maybe we'd be in a different position today. But if the contractor goes off script, no defense. Principle 3, Congress knows how to write immunity when it wants to. Congress knows full well how to make its intention to preclude private liability known. Translation, if Congress wanted to immunize contractors from suit, it would have said so. But guess what? It didn't. Courts shouldn't fill that gap. Does that sound familiar? Principle 4, and this is the punchline. Quote, we decline to extend Yearsley to bar allegations such as Hensley's. Essentially, that just means they decline to extend the rule from another case. So the 6 justices, including Thomas, who wrote a concurrence in a prior case in 2017, saying that qualified immunity has no basis in common law, and then was a dissent in another case in 2020, begging its colleagues to reconsider it. But now him and the majority of the court just said out loud on that page that we will not extend a judge-made defense beyond the narrow circumstance where the government actually directed the conduct. Now, let me ask you a question. Would you agree that every single principle I just told you word for word applies to qualified immunity? Yeah, let me show you. Side by side. Row 1, Thomas today. No preemption without constitutional text or federal statute. Qualified immunity. As we know, there is no text. Section 1983, as passed by Congress in 1871, says that any officer who violates your constitutional rights shall be liable. They don't get to use any defense or immunity, period. No immunity provision, no clearly established law requirement. None of.
So you see how he even refers back to 1871. Now, he didn't finish out the whole statement as far as the 1871, but it was the Ku Klux Klan Act. Okay? I want y'all to recognize this. He even says it himself. All right?
As we know, qualified immunity was invented by the court in the 1960s and then rewritten in the 1980s. Out of thin air, they just assumed that officers should get this good faith defense. And it's only just continued to expand and worsen for Americans since then. Row 2, Thomas today. A contractor only gets a defense when the government directed the very thing at issue. Qualified immunity protects officers for conduct no one directed. So even conduct that violates their own department's written policy, even conduct where the department ends up firing the officers for, the officer still gets qualified immunity. Row 3, Thomas today. Congress knows how to create immunity when it wants. Qualified immunity, Congress wrote Section 1983 not allowing for immunity, but the court added it anyway. Before, Thomas today about Yearsley, the defense applies only when the contractor is being sued precisely for accomplishing what the federal government requested. Qualified immunity protects officers for constitutional violations they were never authorized to commit. Row 5, Thomas today, we decline to extend. Qualified immunity, the court just keeps extending it. Pearson v. Callahan made it easier to grant without even reaching the constitutional question. Courts just ask now, was it clearly established? Decision after decision, judge-made defense grows. This is the double standard. When it's a contractor who may be negligent, let a bomber onto a U.S. base, the court says, no judge-made immunity. Let that tort case proceed. But when it's a cop who tased a kid, shot someone in the back, or beat a handcuffed man 133 times, the court says, here's a judge-made immunity. We invented it. Case dismissed. Same court, same term, different result. I want to show you something. If you're new here, you probably haven't seen this. If you've been here a while, you probably have. A few months ago, I sat down with Professor Alex Reinert from Cardozo Law School. He's the author of the most important academic article on qualified immunity in a generation. He proved that the version of Section 1983 the Supreme Court has been interpreting is literally missing a sentence that Congress actually wrote. And I asked him about Hensley during that interview about this specific case before it was decided.
Interestingly, this term...
So before it was even decided, they're speaking about this case that I utilized before it was done with, right? In relation to qualified immunity in and of itself. And this is why it's so powerful and why I had to bring it in, because I needed to make sure that I could be at least one of the first, if not the first in the nation, to try and combat qualified immunity in the deeper principle way.
Notwithstanding.
Exactly, yep.
There's going to be a case, Hensley versus Fluor Corporation, which poses the question of whether or not to expand the Boyle federal common law defense to a different context. And I'm really interested in what the court does there, because again, if the court is being true to its hostility to federal common law, it should run maybe against common law defenses even more than it might run against federal common law claims.
He called it months ago. He said if the court is honest about what it claims to believe, if it is really hostile to judge-made law, it should run away from judge-made defenses, not just judge-made rights. And in that Hensley opinion, that is exactly what 6 justices did.
If the court was adhering to its principles consistently, qualified immunity would be more tenuous. It wouldn't survive scrutiny. Because if the court is consistent, truly consistent with the reasoning it put on the page in the Hensley case, then qualified immunity collapses. Judge made? Check. No statutory text? Check. Not in the Constitution? Check. Protects conduct the government never authorized? Check. Congress knows how to write immunity and chose not to? Check. So everything Thomas just said about Boyle and Yearsley in this Hensley case applies with greater force to qualified immunity, because qualified immunity isn't limited to people acting within their authority. It's broader. It's worse.
So why is qualified immunity still here? Well, two reasons. First, stare decisis. The court hides behind its own past decisions. They've ruled on qualified immunity so many times that overturning it now feels like institutionally destabilizing, even when the reasoning is indefensible. Second, nobody wants to be the court that tells every police officer in America that they can be personally sued. But here's why that case matters today. The intellectual foundation is crumbling in real time. Thomas has already said in print that qualified immunity has no historical basis. Today, he wrote a majority opinion refusing to extend a parallel doctrine using reasoning that would destroy qualified immunity. Gorsuch and Barrett joined him. Sotomayor, Kagan, and Jackson joined him. 6 judges on the record saying that judge-made defenses don't extend past the narrow circumstance where the government directed the conduct. That's not nothing. That's the scaffolding for the case to end qualified immunity. Somebody just has to bring it. So here's a question I want to leave you
Somebody just has to bring it.
with if it hasn't clicked yet. If a military contractor loses his judge-made defense because he acted outside of his authority, why does a police officer keep his or hers? The court just answered that question for contractors. It needs to answer it for cops. If you think a doctrine invented by judges with no basis in the Constitution or statute that protects conduct the government never authorized shouldn't be the law, well, share this video. If you're a lawyer with a qualified immunity case on appeal right now, you need to read Hensley now.
Oh. I love it, right? So the reason why why I did bring this one up is because thank you to Clearly Established. I literally brought in Floor versus Hensley because I comprehend the deeper principles here, right? The deeper principles of judge-made law being brought against me as far as qualified immunity when they excluded the notwithstanding clause in 1871 Ku Klux Klan Act, which is what allows everybody, right, to bring forth their 1983 claim. All right, and let me see if I can find okay. I think we only have one notwithstanding in this whole thing. Yep, only one. Share. Come back over. And what we'll notice in the Ku Klux Klan Act, they actually excluded the notwithstanding clause, okay? Be it enacted by the Senate when they actually moved everything over into codification, right? Section 1983. They excluded this one phrase, and they did that for a reason. They intentionally did not bring it in. But again, all we have to do is rely on the actual act in and of itself, right? So when we're looking at it, it's April 20th, 1871, and enacted that any person who, under the color of law, statute, ordinance, regulation, custom, or usage of any state shall subject or cause to be subjected any person within the jurisdiction of the United States to the deprivation of any rights, privileges, or immunities secured by the Constitution of the United States shall any such law, statute, ordinance, regulation, custom, or usage of the state to the contrary, notwithstanding, be liable to the party injured in any action, lawsuit, inequity, or other proper proceeding for redress. Straight up. They deleted that bad boy. Notwithstanding. It's all the way. They deleted that completely. All right. So first, what I want to go over is, before we dive into the educational aspect of it, the actual decisions in and of themselves. So when we're looking back, we will notice on March 13th, after going through everything and after summary judgment had been brought forth from the defendants, that we had a findings and recommendation coming from the magistrate judge. Okay, and this is on the lower side of it. And the magistrate made a decision such as this. Defendants in the city of Hood River and the claims, Cameron brought forth. Background. Of course, we already know plaintiff was stopped after defendant police officers observed him driving a vehicle without registration plates. They really didn't observe me driving the vehicle without license plates. Maybe later, but they didn't notice even until after they got out the car. While officers were speaking to the driver of another vehicle stopped at the same time, plaintiff exited his vehicle and attempted. Look at how they're now she's utilizing their version of the story and attempted to walk away from the scene of the traffic stop. Well, I wasn't being stopped. I had already parked. I wasn't attempting to walk away from anything. I was getting out to walk and stretch out my leg because I had been driving from so long from Portland to Hood River for an appointment. Officer Delancey observed a piece of paper that appeared to have been placed to cover the vehicle VIN's number. Well, that's not illegal, okay? But we'll continue. When defendant officers informed plaintiff that he was being detained as part of a traffic stop and asked him to return to his vehicle, plaintiff refused and asked to speak to a sergeant. Plaintiff was informed that a sergeant was not available and that if he failed to do as instructed, he would be placed in handcuffs. Plaintiff ignored Officer Delancey's instruction, or should I say request, and again asked for a sergeant. Plaintiff also asked the officers for their names and badge numbers, which the officers provided. No, they didn't. That's a complete lie. 2 of the officers provided them. 1 of them didn't even get a chance to because I was already put in handcuffs. So again, she's just like falsifying the record. It's not true. She should have been more specific and clarified exactly. Oh, y'all can't see my screen? Is that what's going on? Is that happening again?
I see it.
Yeah, I see it.
Okay, Brett, not sure exactly what's going on. Plaintiff recorded the interaction on his cell phone. Plaintiff was again told that the sergeant was not available and was then placed into handcuffs and walked back to his vehicle. Okay, this is what's interesting. She left out everything in relation to me being arrested for obstruction. I was falsely arrested for obstruction of justice, matter of fact, which is not even a statute in Oregon to be arrested on. It doesn't exist. So she intentionally right here leaves that out, okay, which is a huge dispute as far as the material facts are concerned that she just clearly leaves out. So again, plaintiff was again told that the sergeant was not available and then was then placed into handcuffs and walked back to his vehicle so that the officers could proceed. And I wasn't just placed in handcuffs. I was arrested. Okay, my Miranda rights were read. It wasn't just detained. I wasn't just placed in handcuffs. I was arrested with Miranda rights being read. Okay, so again, intentionally falsifying or not including all of the facts. And walked back to his vehicle so that officers could proceed checking his registration and license. During the handcuffing process, plaintiff was fully cooperative. Officer Delancey removed plaintiff's phone during the handcuffing process to ensure that he did not stop the recording. What do you mean? He definitely took the phone, turned it off, and then put it in my pocket. He placed the phone inside plaintiff's pocket and advised plaintiff that he was not turning off the phone. Just because he said that doesn't mean he didn't do it. He did do it and did not have a valid driver's license, and that his vehicle registration expired in 2021. There's no way for them to understand that at that point, so I don't know why she put that in there like that, because they didn't have no eligibility to search me or my name because I didn't have a plate on, and that his vehicle lacked liability insurance. So this was all after. But yet she put it before. I don't know why. Well, we clearly know why. Plaintiff argued that a valid driver's license was not necessary because he was not operating his vehicle in a commercial capacity and that he did not need valid liability insurance. Now we can start to see the depths of what is going on here, right? That I am bringing forth everything that I have stood for 12 years now on not having a driver's license and no insurance, okay? And that these officers, essentially in my situation, confirm that it is true. They don't want to talk about this. They're trying to push me to the side because I have like one of the best situations for the right to travel as far as cops recognizing that, right? And me being able to articulate it, not being even ticketed whatsoever. Plaintiff then requested to be freed from handcuffs. See, so this was, again, all of this was kind of before, but not necessarily. So plaintiff then requested to be free from the handcuffs, which Officer Delancey obliged. Plaintiff was in handcuffs for approximately 7 minutes. Officer Delancey again advised plaintiff that his cell phone was in his jacket pocket and that he could take it out to continue recording. Nah, it's all right. Why? Because I'm already looking at the body camera and I see it flashing. I know he's recording, so I know I'm going to get this. I ain't no tripping. I'm not worried about recording again. I want to start arguing and bringing forth my truth. After obtaining the vehicle's VIN number and verifying the vehicle had not been stolen, Officer Delancey released plaintiff with the warnings as to all infractions without further incident. He really didn't even give me warnings. He was just like, be safe out there. Others might fuck with you. Plaintiff now brings the claim for unlawful arrest, excessive force, and it was an arrest. I was read my Miranda rights. So this is very true. Excessive force and kidnapping in violation of the Fourth Amendment, retaliation in violation of his First Amendment, which was me asking for the badge numbers, violations of his due process and equal rights under the 14th, and unconstitutional policies by the department that permitted these violations under Monell versus Department of Social Services. Now, the summary judgment is appropriate if the pleadings, depositions, answers to interrogatories, affidavits, and admissions on file, if any, show that there is a genuine dispute as to any material fact, and the moving party is entitled to judgment as a matter of law. Okay, all right, let's read this again. That there is no genuine dispute as to any material fact, and the moving party is entitled to judgment as a matter of law. Okay. Substantive law on that issue determines the materiality of a fact. Okay, cool, good. I'm glad you're saying this. Whether the evidence is such that a reasonable jury could return a verdict for a non-moving party determines the authenticity of the dispute. The moving party has the burden of establishing the absence of a genuine issue of material fact. So if the moving party shows the absence of a genuine issue of material fact, the non-moving party must go beyond the pleadings and identify facts which show a genuine issue for trial. Okay, cool. Special rules of construction apply when evaluating a summary judgment motion. All reasonable doubts as to the existence of genuine issues of material fact should be resolved against the moving party. And all inferences to be drawn from the underlying facts must be viewed in the light most favorable to the non-moving party. Oh, so they should be viewed in the light most favorable to me, should you say? Oh, okay. Discussion. The court thoroughly reviewed the 163 pages of briefing in this matter, as well as plaintiff's 555 pages of attachments. The briefing also included a surreply filed by the plaintiff, a surreply to surreply filed by defendants, a second surreply by the plaintiffs, as well as a second surreply filed by defendants. The surreply briefing also came with many pages of attachments. Finally, the court also carefully reviewed the defendant's officer's body-worn camera footage, which documented the entire encounter with plaintiff. Based on this review, and in consideration of the relevant Ninth Circuit and U.S. Supreme Court law, and considering the facts in light most favorable to the pro se plaintiff, really? The court finds no genuine issue regarding any material fact and that the defendants are entitled to a judgment as a matter of law? Really? You really looked at it in favor to me? Really? Okay. Specifically, after thorough review of the voluminous record, I find no contradiction of defendant's facts by the evidence in the record. Really? Okay. All right. Okay, if you say so. Plaintiff's Fourth Amendment claims for unlawful arrest, excessive force, and kidnapping failed based on settled Ninth Circuit law. Okay. Handcuffing as means of detaining an individual does not automatically escalate a stop into an arrest. I was read my Miranda rights. I was arrested for obstruction of justice. What do you mean? That's why you didn't include it. You didn't include that I was arrested and read my Miranda rights. Why didn't you include that? What is going on here? I wasn't just handcuffed. I was arrested for obstruction of justice. Okay. All right. Then we're moving on to, again, characterizing force involved in normal handcuffing procedure as minimal. Well, it wasn't normal. I should have never been put in handcuffs. I never met any of the gram factors whatsoever. That was clearly brought forth in the depositions heavily. And I made them admit to all of them, all four. We hold that under the Fourth Amendment, it is reasonable for an officer to order a passenger back into an automobile that he voluntarily exited because the need for officers to exercise control over individuals during a traffic stop. I was not stopped. I was not stopped. They pulled over someone else completely, walked up to that car, and was handling that ordeal. Then when they saw me walking and they knew that I had possibly come out of my vehicle, oh, he's got private plates on. Call him back. Get his ass too. I'm not in a traffic stop. What are you talking about? We arguing it right now. I'm not in control of that vehicle whatsoever. You pulled over somebody else. This was, again, they're late. This is a total disputed fact, whether I was in a traffic stop or not. But it's not, it's just, oh, yep, you were in a traffic stop. No, I wasn't. The need for the officers to exercise control over individuals encountered during a traffic stop outweighs the marginal intrusion on the passenger's liberty interest. Okay. Plaintiff next alleges the First Amendment claim for retaliation. I find no evidence on the record here that plaintiff's handcuffing had any relationship or casual connection to the protected activity he alleges. How so? I'm saying I don't want to go back to my car because it's not a traffic stop. And then I'm asking for a sergeant. Y'all ain't giving me one. You saying there ain't one available. Then I ask for your badge numbers. Then you arrest me. That's retaliation. I'm not doing that as you want me to do, standing on my rights, so you're going to arrest me now and make me do what you want me to do. That's what are you talking about? Plaintiff must demonstrate, number one, that he engaged in a constitutionally protected activity. Did. Two, as a result, he was subject to adverse action by the defendant that would chill a person of ordinary firmness from continuing to engage in the protected activity. You did. You put me in handcuffs for a charge that did not exist when I was asked for badge numbers. And three, there was a substantial casual relationship between the constitutionality protected activity and the adverse action. Plaintiff alleges the 14th Amendment due process and equal protection violation. Plaintiff asserts he was arrested without first affording him procedural safeguards required by due process, specifically defendant's failure to articulate a legitimate basis for his detention, which they did. He arrested me for obstruction of justice. Come on, bro. What are you talking about? And denied him an opportunity to speak with a supervising officer. The U.S. Supreme Court has held, however, that while it is assuredly good police practice to inform a person of the reason for his arrest. Wait. Oh, is my screen showing or no? Yes? Okay.
Yes, I see it.
Okay, he is taken into custody. We have never held that it to be constitutionally required. Now, the court knows of no legal authority requiring that the plaintiff be provided with an opportunity to speak with a supervising officer before he can be arrested or detained. Regarding plaintiff's equal protection claim, plaintiff argues he was singled out for detention or arrest when he was placed in handcuffs. I wasn't just placed in handcuffs, I was arrested. Why do you keep doing it like that? Like, what is going on here? It's very weird. To prevail on the class of one claim, plaintiff must show that he has been intentionally number one, treated differently from others in similar situations, and that, three, there is no rational basis for the difference in treatment. Well, I'm walking on the sidewalk, of course. No, most of them know that you can't just come up and put somebody in handcuffs because they're on the sidewalk walking and don't want to talk to you. Plaintiff was alone at the time of the stop and was the only individual who attempted to get out of his vehicle and leave the scene. The scene of what? Someone else being stopped? Like, I'm not being stopped. There was no traffic stop on me. So what are you talking about? Leave the scene. Who attempted to get out of his vehicle? I wasn't involved with anything going on. What are you talking about, Judge? Plaintiff is unable to identify any other similarly situated comparators. Plaintiff claim fails as a matter of law. Plaintiff also alleges a substantive due process claim for failing to provide him with an opportunity to adjust his prosthetic limb. Specifically, plaintiff alleges he was denied a reasonable accommodation and relies on City of Canton versus Harris. There, the plaintiff brought a substantive due process claim for a right to receive adequate medical care while in police custody after she repeatedly collapsed and incoherent remarks following her arrest. The court assumes that plaintiff's claim here alleges that for a failure to adjust his prosthetic limb violated his substantive due process right to adequate medical care while in police custody. Plaintiff is unable to establish any of the necessary elements for a pretrial detainee to prevail on a claim of inadequate medical care. The interaction at issue was recorded via the officer's body camera, and at no point did plaintiff mention a prosthetic, even during the 7 minutes when he was handcuffed. Finally, plaintiff alleges a Monell claim, arguing that the city of Hood River failed to adequately train its officers on the lawful scope of their authority to carry out detentions, their authority to use force, a suspect's right to record an encounter, and the proper handling of individuals with unique or disability-related circumstances. The record here is no evidence of a deficient municipal training policy or that any gaps in training would have amounted to deliberate indifference. To demonstrate deliberate indifference, a pattern of similar constitutional violations by untrained employees is ordinarily necessary. Moreover, the individual defendants are entitled to qualified immunity. Government officials who violate another's rights are immune from liability under Section 1983 unless the unlawfulness of their conduct was clearly established at the time. Well, it's clearly established that you can't just come up and arrest people on the streets, especially utilizing fake charges. There was no obstruction of justice. And even if my license plate or my VIN was covered, that is not illegal without there first being, it's secondary. There has to be a first charge first, such as stolen, like the vehicle is known as stolen. There's some kind of first element of a crime, and then covering the VIN to cover up that crime as well. You see what I'm saying? It's not just, oh, you covered up your VIN, so that's completely illegal. That's not how this works. It's like, oh, we're asking you for your ID, but there's no crime, first off, that we're asking you for your ID. It doesn't work that way, okay? Anybody can cover up their VIN at any point in time, and nobody can tell them otherwise. It has to be first in correlation with a crime of the vehicle in and of itself, and that you're covering up the VIN to conceal that it's either stolen, that there's stolen parts, or that it was involved in some sort of crime in some form or fashion, okay? Not just covering the VIN in and of itself, okay? Let's see, where are we at? Okay, knowingly violate the law. The plaintiff bears the burden of showing that the rights allegedly violated were clearly established. I really did. I don't see how you don't see that. But plaintiff here is unable to make that showing. Okay. Therefore, defendants are also entitled to summary judgment on the basis of qualified immunity. Okay. So she makes a recommendation that for the foregoing, this recommendation is not an order that is immediately appealable to the Ninth Circuit Court of Appeals. She sent it on up to the federal judge to make a decision. Okay, so then we go ahead, and what I end up doing is I have to come through and bust it on down with a 45-page objection to her decision. I had to be like, listen here, I'm not gonna let this little what you've brought forth take away everything that we've done and the deeper comprehension and understanding of what's going on. There's 19 objections, y'all. Okay, 19 of them. All right. The very purpose of a Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy and to place them beyond the reach of the majorities and the officials, to establish them as legal principles to be applied to the courts. Okay. Again, we're doing these objections, which afforded the parties 14 days to file specific written objections. The FR, or the findings and recommendations, recommends granting the defendant's motion for summary judgment in its entirety and dismissing this action. In reaching this recommendation, the magistrate concluded that there is no contradiction of defendant's facts by the evidence in the record. This conclusion is not merely erroneous, it is demonstrably and irrevocably false when measured against the sworn deposition testimony of the defendant officers themselves and the verbatim transcript of the body-worn camera footage. The FNR commits the precise constitutional error condemned by the Supreme Court in Tolan. It resolves genuine disputes of material fact in favor of the moving party and credits defendants' post hoc rationalizations over real-time evidence and ignores the non-moving party's evidence entirely. The magistrate judge analysis is infected by three fundamental errors that permeate the entire recommendation. First, the FNR completely omits the actual stated basis for plaintiff's arrest. Completely left it out, which is obstruction of justice, a charge that defendant Delancey admitted under oath does not exist as a statute or code in Oregon. Instead, the FNR adopts defendant's post hoc rationalization, the covered VIN, as the undisputed basis for the detention, despite the transcript proving the VIN was not mentioned until after the plaintiff was already in handcuffs. Crazy work, bro. Crazy work. Second, the FNR, facts and recommendations, or findings and recommendations, characterize the encounter as a traffic stop of plaintiff, when the undisputed evidence, including defendant's sworn own testimony, establishes that officers stopped a different vehicle for speeding, that plaintiff was already parked and not operating his vehicle, and that the encounter was, quote, not a traffic stop in the traditional sense, because it wasn't a traffic stop at all. So third, the FNR ignores the officer's own admissions that plaintiff was never asked for his identification prior to being handcuffed. Never asked. She ignores that too, doesn't bring that in. That plaintiff was cordial throughout the encounter, and that asking for badge numbers does not constitute obstruction, and that no citations were issued for any offense. These are not minor discrepancies. They are the genuine disputes of material fact that go to the heart of every constitutional claim in this action. Under the mandatory standard of Anderson versus Liberty Lobby and the heightened scrutiny required in 1983 cases under Tolan, summary judgment must be denied where, as here, the evidence weighed in light most favorable to the non-moving party, which is me, creates a genuine issue for trial, or genuine issues, should I say. Plaintiff respectfully requests that this honorable court conduct a de novo review pursuant to 28 U.S.C. 636 B1C and reject the FR in its entirety. Deny defendant's motion for summary judgment and set this matter for jury trial, which is what is supposed to happen, of every citizen to have his claims heard by the jury of his peers. Okay? Again, a de novo review is mandatory, all right? Unyielding summary judgment standard. Summary judgment is appropriate only if there is no genuine dispute as to any material fact and the movement is entitled to the judgment as a matter of law. Okay? The Supreme Court has established a dispute is genuine if the evidence is such that a reasonable jury could return a verdict for the non-moving party. Okay? For me. At summary judgment stage, the judge's function, listen to this. This one is very important, and I need y'all to understand this in your federal civil rights suits. At summary judgment stage, the judge's function is not himself to weigh the evidence and determine the truth of the matter, but to determine whether there is a genuine issue for trial. You're not supposed to be the one that's determining at this point and weighing the evidence, essentially. Just if there's any kind of genuine disputes between the facts of what their version is and what my version is. And even if that was such the case, the court must view the evidence in light most favorable to the opposing party of the actual summary judgment, which is me. All justifiable inferences must be drawn in favor of the non-moving party. It's clear. You got to move in favor of me. You have to look at it in the light of mine. Credibility determinations and weighing of the evidence and drawing of legitimate inferences from the facts are jury functions, not those of a judge. It's very clear what your responsibility is. The non-moving party need not produce evidence in a form that would be admissible at trial in order to avoid summary judgment. What are you talking about? That's coming out of case law. Y'all want to bring up case law? I'm bringing it in too. The question is whether the evidence viewed favorably to the non-movement presents a sufficient disagreement to the required submission to a jury. That's all I got to do. All I got to do is present a sufficient disagreement to their actual facts that they're bringing forward. I don't have to, we're not running trial right now, bro. I just have to be able to dispute it in a sufficient disagreement way. Heightened scrutiny. The Tolan mandate in Tolan versus Cotton, the Supreme Court issued a per curiam reversal of a lower court that had granted summary judgment and qualified immunity by failing to view the evidence in light most favorable to the plaintiff. Well, looky there. The court held, quote, in holding that Cotton's actions did not violate clearly established law, the Fifth Circuit failed to view the evidence at summary judgment in light most favorable to Tolan with respect to the central facts of this case. By failing to credit evidence that contradicted some of its key factual conclusions, the court improperly weighed the evidence and resolved disputed issues in favor of the moving party. Well, looky there. The magistrate judge's FR commits the exact error condemned in Tolan. By concluding there is no contradiction of the defendant's facts, the magistrate judge improperly weighed the evidence, credited the defendant's post hoc rationalizations, and ignored the devastating admissions in the officer's own depositions. Pleadings and filings by pro se litigants must be liberally construed and held to less stringent standards than formal pleadings drafted by lawyers. The court has a duty to ensure that pro se litigants do not lose their right to a hearing on the merits due to technicalities. Okay? So then now we're getting into the actual issues here. All right. The central false premise. The findings and recommendations issued by Magistrate Jolie Ruscio rests upon a single sweeping declaration that functions as a load-bearing wall of the entire recommendation. Quote, I find no contradiction of defendant's facts by the evidence in the record. Are you kidding me? Are you kidding me? Literally, are you kidding me? Let that sink in. I find no contradiction of the defendant's facts by the evidence in the record. Y'all tell me how that is possible. They're saying it's a traffic stop. I'm out of my car walking over 75 yards away before they're even yelling at me. And there's no contradiction of the facts?
They always try to rewrite the story. They're gaslighting you.
She didn't look at it in favor of me, though. I say that it wasn't a traffic stop. They say that it is. She's supposed to look at it in favor of me. That's a dispute of a material fact. Correct or incorrect?
That's correct. I don't even think she read your stuff. I think she watched the video cam footage and took her limited freaking knowledge of law and applied it to you.
This statement is not a matter of competing inferences, reasonable disagreement, or judicial discretion. It is objectively, demonstrably, and irreconcilably false when measured against the sworn deposition testimony of the defendant officers themselves and the verbatim transcript of the body-worn camera footage. The defendant officers under oath, subject to penalty of perjury, provided testimony that directly contradicts the factual narrative of magistrate judge adopted wholesale from defendant's briefing. The Supreme Court has unequivocally, at the summary judgment stage, the judge's function is not himself to weigh the evidence and determine the truth of the matter, but to determine whether there is a genuine issue for trial. Credibility determinations, the weighing of evidence, and the drawing of legitimate inferences from the facts are jury functions, not those of a judge. How clear does it need to be? By declaring that no contradiction exists in the record, the magistrate did precisely what the Supreme Court forbids. She weighed the evidence, resolved disputes in favor of the moving party, and determined the truth of the matter. All functions reserved exclusively for the jury. This error is not harmless. It is structural. Because the magistrate's no contradiction declaration is false, every legal conclusion that flows from it is built upon a false factual foundation. The Fourth Amendment analysis is corrupted. The First Amendment analysis is corrupted. The excessive force analysis is corrupted. The qualified immunity analysis is corrupted. The Monell analysis is corrupted. Each must be reviewed de novo by this court, and each must be reversed. False in one thing is false in everything. The magistrate judge's foundational factual premise is false, and therefore the entire edifice constructed upon it must fall. Contradiction 1, the traffic stop. Okay? The magistrate judge states that Plaintiff Wilson was stopped after a defendant police officer observed him driving a vehicle without registration plates. The contradiction. The body-worn camera transcript and defendant Delancey's sworn deposition testimony directly contradict this finding. The transcript establishes that officers were conducting a stop on a different vehicle, an SUV that had been speeding. It was only after defendant Delancey exited his patrol vehicle to approach that other vehicle that he noticed plaintiff's car already parked. Delancey's own words captured in real time were, "He don't have a plate on his car, so call him back. Call him back." Plaintiff was already parked. Plaintiff was not stopped. Plaintiff was not operating a moving vehicle. The officer did not initiate a traffic stop on plaintiff. Under oath, defendant Delancey confirmed this sequence. Was Mr. Wilson operating his vehicle when you made contact? No. So this was actually not a traffic stop in the traditional sense, was it? No. Defendant Griffin further confirmed this consensual nature of the encounter in his own deposition. Why this contradiction is material. The distinction between a traffic stop and a consensual encounter is not semantic. It is constitutionally dispositive. Under Terry, an investigatory stop requires, at minimum, reasonable articulable suspicion that a criminal activity is afoot. Under Florida versus Bostic, a consensual encounter requires no suspicion at all, but it also creates no legal obligation to comply with officer's request. Exactly what we're doing over in the WSP. It's the exact same thing. If this was a consensual encounter, as Delancey and Griffin admitted, which they did, Griffin definitely admitted it in his deposition, then plaintiff has an absolute constitutional right to decline to provide identification, to ask for badge numbers, and to walk away. The judge's magistrate's mischaracterization of the encounter as a traffic stop retroactively manufactures a legal duty that never existed and uses that manufactured duty to justify every subsequent action by the officers. Okay? Contradiction 2, the fabricated obstruction of justice, which she never mentions. The magistrate judge never once mentions the charge of obstruction of justice. The word obstruction does not appear in the FNR's factual recitation. The FNR instead adopts the post hoc rationalization of a covered VIN as the basis for the detention and arrest. What are you talking about? What are you talking about? In real time, while placing plaintiff in handcuffs, I'm detaining you for obstruction. This was the contemporaneous stated basis for the arrest, not the VIN, not the plates. Obstruction. Under oath, defendant Delancey was confronted with that fact. Obstruction of justice is not a statute in Oregon, is it? No, it's not. Defendant Delancey arrested plaintiff for a crime that does not exist in the state of Oregon. He then admitted this under oath. The magistrate judge FNR does not mention this admission. It does not address it. It does not analyze it. It simply omits it entirely. What the hell is going on, y'all? Y'all please tell me what's going on here. Y'all let me.
The judge is using AI.
Corruption,
bro. What is going on, bro?
CYA recovery.
corruption,
Lying by omission.
Lying by omission. Ah.
They're just not saying it, so it's just not true.
Why this contradiction is material. This is not a peripheral disputed fact. This is the core of the entire case. Probable cause requires a reasonable belief that a person has committed an actual existing crime. An arrest predicated upon a charge that does not exist as statute cannot, as a matter of law, be supported by probable cause. The actual Oregon obstruction statutes, which is obstructing governmental or judicial administration, or the interfering with a police officer, require specific elements that plaintiff's conduct does not satisfy. Okay? Or arrest requires that a person refuses to obey a lawful order by a police officer or peace officer, and that refusal creates a risk of public injury. Asking for badge numbers creates no such risk. Delancey himself admitted, can requesting badge numbers constitute obstruction of justice? No. Then you got the Devenpeck preemption. Defendants will inevitably argue that under Devenpeck, an arrest may be justified by probable cause for any offense, not merely the one stated by the officer at the time. This argument fails for two independent reasons. First, Devenpeck strictly requires that probable cause for the unstated offense exist at the moment of the arrest. Because the VIN was not discovered until after the plaintiff was already in handcuffs, it cannot retroactively supply the probable cause that was absent at the moment of the seizure. Probable cause must be assessed based on the facts known to the officer at the time of the arrest, not later. Second, the only other potential of offense, driving without plates, is inapplicable because plaintiff was not driving. He was parked. Which legal standards this affects? Fourth Amendment, First Amendment, fabricated charge was deployed in direct retaliation for plaintiff's exercise of his right to ask for badge numbers. Qualified immunity, no reasonable officer can believe that arresting a citizen for a crime that does not exist in the jurisdiction is lawful. And then the Monell, the 3 officers participated in an arrest for a non-existent crime, demonstrating a systematic failure to train. Why summary judgment cannot be granted? The magistrate judge's entire qualified immunity analysis is built on the then rationalization, a justification that was never articulated at the moment of the arrest. A reasonable jury, hearing Delancey's real-time statement, "I'm detaining you for obstruction," and his deposition admission, "Obstruction of justice is not a statute or code in Oregon," could find that the arrest was made without probable cause and that the VIN was a post hoc fabrication and that the arrest violated clearly established Fourth Amendment law. The omission of this central fact from the FNR is not a minor oversight. It is a structural error that voids the qualified immunity analysis entirely. Now listen, I'm just going to leave it there on this FNR and my argument because we're only on contradiction 3 and objection, right? That's not going to be the basis of today's thing, but I am showing y'all that, and to be honest with you, I can probably bring it in real quick to y'all. Let me see. If y'all just wanted to actually read through it and then utilize it in any form or fashion on the depths that I've brought forth on this one. Where's it at? Documents, April.
Yeah, I definitely appreciate you sharing that, Cam.
Yeah, I got y'all on this one. The finished reply to summary judgment, final objections, comprehensive dismissal. Where's it at? Objections.
Cam, I just want to interject here real quick. And this is a common practice of these judges to rewrite the history of the case and omit facts and fabricate facts because they think if they rule against you that you'll just go away,
Right. Not going away.
It's the ORS 174.010 where judges can't legislate from the bench like they make up navigational rivers are a road.
Yep.
And then you kick it up to a higher court where you're going to do it.
Yeah. Oh, yeah. We'll get there. So now we're going to go through just a little bit of the plaintiff's supplemental memorandum in law that support the objections to the findings and recommendations, right? Now, what I did and why I brought the video first to showcase was that I'm not just utilizing this case as far as the argument is concerned for my situation. I am bringing in Hensley versus Floor Corporation, all right? And I brought this memorandum in because it was newly decided, and it parallels qualified immunity and why qualified immunity is hanging on by a thread, okay? Where those docs shareable in chat, it says this content cannot be viewed. Can y'all look in the chat real quick and just verify that you can download those? It worked for everybody else. I'm not sure what's going on with your KP. Yep, everybody else is getting it okay. All right, so the doctrine of qualified immunity as applied by magistrate, the judge, in the findings and recommendations rests upon a legal foundation that has now been definitively and irrevocably shattered by the Supreme Court of the United States. On April 22nd, less than 6 weeks after magistrate judge issued her, and this is what's funny, okay? Now, I'm going to point this out because in the federal judge's decision, she says that that this Hensley versus Floor Corp was actually decided before the findings and recommendations of the magistrate judges. It wasn't. This was actually decided after. Okay, so there's a mistake right there that we're going to call out as well. Okay, but anyways, this again, less than 6 weeks after the magistrate issued her findings and recommendations. It was not before. Okay, so apparently there's some big mistakes here, bro, that we really have to understand. You have to look at things and the statements that they're making. The Supreme Court issued its opinion in Hensley versus Floor, all right, authored by Justice Clarence Thomas and joined by a six justice majority comprising justices, all of the six ones, right? That opinion articulates 5 governing principles regarding the judge-made defenses that, when applied to the undisputed record in this matter, categorically and irrevocably preclude the application of qualified immunity to Officer Emelike Delancey. This is not a closed question. Officer Delancey arrested plaintiff Wilson for obstruction of justice, a charge that Delancey himself admitted under oath does not exist as a statute in the state of Oregon. No law, no policy, no directive, and no authorization from the city of Hood River or any governmental authority directed, requested, or sanctioned Delancey to fabricate a non-existent criminal charge to effectuate a retaliatory arrest of a man who was doing nothing more than exercising his First Amendment right to ask for badge numbers. Under Hensley's 5 principles, judge-made defenses protect only conduct the government actually authorized. The government never authorized the fabrication of a crime, did they? Where there is a right, there is a remedy. The remedy here is a jury trial. Okay, KP, let me do it like this, my boy. Let me do it like this. I see you're having issues, so I will bring them in one more time, and maybe they'll load for you. If not, they are in my Hood River channel. Okay, they're most definitely in the Hood River, Cam Hood River Civil. All right, in Discord, you can definitely find them. Yeah. All right, so let's keep going. Oh, not that one. Oh, not that one either. Wait, is it this one? Maybe it's this one. Yep, it's this one. Okay, sorry. Oh no, she went up pretty high. All right, so furthermore, as established by the exhaustive historical scholarship of Professor Alexander Reinert of Cardozo School of Law, the version of 42 U.S.C. Section 1983 upon which the magistrate judges relied itself a corrupted text, a statute from which a critical notwithstanding clause expressly enacted by the 42nd Congress in 1871 was erroneously omitted by the reviser of the federal statutes in 1874. That omitted clause explicitly abrogated all state law immunities and customs. The magistrate judge granted immunity based on a doctrine that Congress itself prohibited in the original statute. This court must correct that error. So I'm telling them, you must stand on your oath. You must stand on the correct text of the actual act. Don't sit here and be acting like, oh, I'm going to do what everybody else does. No, you have a moral obligation and duty, a ministerial duty to do right. Go ahead.
What about stare decisis?
Bro, they can do that, but the act is the act. You see what I'm saying? That's what I'm trying to do.
Stare decisis be damned when it goes against the Constitution.
Or when it goes against an act that Congress put in place to protect me. You know what I'm saying? I'm trying to invoke it. I'm invoking it. Go ahead.
But what I'm getting is, sure, you can bring forth that argument.
Well, they're just judge made. It's judge made.
Yeah, I know, but the lower court is going to say, hey, the Supreme Court says the opposite of what you're saying, and I have to go by what the Supreme Court says.
That's for sure. I get that, and we'll go over that too.
And so you just have to go, we're just going to have to go through the appeals all the way up to the Supreme Court.
Correct. If I have to go there, we're going to see, though, because I got something coming up. Watch, I'll show you. So the supplemental memorandum of law is submitted pursuant to Federal Rules of Civil Procedure and was timely filed within the extended deadline as ordered by this court. Plaintiff respectfully requests that this court treat the memorandum as supplemental authority to his objections and apply the controlling principles in Hensley versus Floor to deny qualified immunity, reject the findings and recommendation, and set this matter for jury trial. Okay. Now let's see.
One day they'll be able to say qualified immunity no longer applies because Wilson versus the United States.
I'm trying, bro. That's the whole point why I did this, bro.
I'm gonna be using it myself.
I'm not just fighting the illegality of what these officers did. I'm trying to end qualified immunity. Okay. And to be honest with you, maybe these judges notice what I've done and they're saying, we're just going to put these blanket responses out here and let him actually take it up to the higher court and see if he gets any traction. I know, bro, that I'm the first one to bring forth this argument to the depths that it is being brought forth. I know it.
That's been my whole point with this whole administrative stuff and approaching them. We try to approach them on principle and what's right, and they don't move. Their whole shit is deny.
Well,
until
listen,
we absolutely.
Well, why is that? This lower court can't go against what the higher court stated. So maybe they're saying, you know what? Take it up. Take it up to the higher court on these deeper principles.
I think that there's something to be said about that, Cameron, because I think that they're so used to people not even knowing or having the knowledge that they can bring it up to a higher court or that an appeal is an option or any of those things. So the second that you hear a lower court judge and you don't have, it's kind of ignorance, right? You don't have any clue what a higher court is like. Even in my situation, I don't have any clue. I've never gone to a higher court. Where when I hear a lower court judge say something, I think that that's, the end of the road, and it's really not.
It's really not. Yep. So the original text, we already know what's going down in the 1871, right? Contained the notwithstanding clause that explicitly overrode all state law customs, usages, and immunities, expressio unice ex exclusio authorius, because the expression of one thing is the exclusion of another. Congress expressed liability and an excluded immunity. Of course, Professor Alexander of the Cardozo School of Law, in his landmark article, Qualified Immunity's Flawed Foundation, in 2023, unearthed the original text of the Civil Rights Act of 1871, which is the Ku Klux Klan Act, from the statutes at large. The statute, as enacted, read, in relevant part, any person who, under the color of law, statute, ordinance, regulation, custom, or the usage of any state shall subject or cause to be subjected any person within the jurisdiction of the United States to the deprivation of any rights, privileges, or immunities secured by the Constitution of the United States shall any such law, statute, ordinance, regulation, custom, or usage of the state to the contrary, notwithstanding, be liable for the party injured or in any action of lawsuit, inequity, or other proceeding for redress. The italicized notwithstanding clause is the critical text. It was deliberate, affirmative, stated by Congress that no state law, custom, usage, or immunity, including common law immunities for officers, could defeat liability under the new statute. Congress wrote this clause specifically because the Reconstruction Congress understood that the southern states would attempt to invoke state law, customs, and immunities to shield officers who violated the constitutional rights of freedmen. The notwithstanding clause was Congress's answer. Notwithstanding any such state law defense, the officer shall be liable. For reasons that remain unexplained, the reviser of the federal statutes omitted the notwithstanding clause when he compiled the first edition of the revised statutes in the United States in 1874. This was not a legislative act. Congress did not repeal or amend the notwithstanding clause. A single unelected reviser whose accuracy was so poor that Congress ultimately fired him simply failed to copy it. As Professor Reinert documents, quote, the distinction between Section 1983 and as enacted and as reflected in the United States Code is not the product of any positive lawmaking. The reviser's error was never corrected in subsequent editions of the United States Code, so the controlling statutory authority on this point is unambiguous. Title I of the United States Code provides that for titles that have not been enacted into positive law, including Title 42, which contains Section 1983, the Code is only prima facie evidence of the law, while the statutes at large are legal evidence of law. 1 U.S.C. Section 204A. The Supreme Court has recognized this distinction, holding that, quote, the Code cannot prevail over the statute at large when the two are inconsistent. The statutes at large contains the notwithstanding clause. The notwithstanding clause abrogates all common law immunities. The magistrate judge's application of qualified immunity violates the express, enacted will of Congress. Do you see how deep I'm getting? I'm not just surface level here on, I'm getting deep. You're violating now, Judge, regardless of stare decisis, regardless of what other people have said, you're violating. I'm bringing it to you, and you're not making the proper decision. Okay, if you want to do so. This court should note that while the Supreme Court has not yet directly addressed the implications of the notwithstanding clause in a 1983 case, the historical evidence is compelling and has been cited by 111 scholarly works since its publication. The argument reinforces and is reinforced by the 5 principles articulated in Hensley Floor, discussed below. Together, they establish that qualified immunity is a judicial creation that contradicts the expressed will of Congress. This is not merely an academic argument. The Supreme Court's doctrine of qualified immunity rests entirely on the premise that Congress, in enacting Section 1983, intended to preserve common law immunities. It's the whole point. We're in Article 3 court. Hello? Quote, we therefore hold that government officials performing discretionary functions generally are shielded from liability for civil damages insofar as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. That premise is false. Congress intended the opposite. The notwithstanding clause proves it. The magistrate judge's qualified immunity analysis is built on a foundation of sand. Okay? Now, even setting aside the original text of Section 1983, the Supreme Court's decision in Hensley versus Floor issued just six weeks after the magistrate judge's findings and recommendation. Again, remember, this was after, it's not before, after establishes 5 governing principles that categorically preclude the application of qualified immunity to Officer Delancey. Although Hensley addressed the yearsly government contractor defense rather than the qualified immunity directly, the principles Justice Thomas articulated regarding the constitutional limits of all judge-made immunity defenses apply with equal, if not greater, force to the judge-made doctrine of qualified immunity. Both doctrines share the same structural defect. They are judicial creations that lack any textual basis in the constitutional or any federal statute enacted by Congress. Y'all violating y'all's own rules. Y'all violating y'all's own rules. The 6-justice majority in Hensley compromises Justice Thomas, Sotomayor, Kagan, Gorsuch, Barrett, and Jackson. It is precisely the cross-ideological coalition that has, in various individual writings, expressed skepticism about qualified immunity. Justice Thomas himself, in his concurrence in Ziegler, wrote, quote, "We have substituted our own policy preferences for the mandates of Congress by conjuring up blanket immunity and then failed to justify our enacted policy." Let's read that again. Thank you, Thomas. Thank you, Clarence. Quote, "We have substituted our own policy preferences for the mandates of Congress by conjuring up blanket immunity and then failed to justify our enacted policy." Wow. Wow. Thank you, my bro.
I like how he says we.
Bro.
He says we. The whole thing that because he's Supreme Court, that covers every last thing, all the way down to ALJs, administrative law judges.
Yeah, he's taking responsibility. Yeah, he's taking responsibility. Right?
Yep. Thank you, Clarence. Clarence is the man. I like him.
Bro.
Clarence
He's really
is awesome.
good.
Yep.
Yeah, Clarence is awesome,
like
bro.
him.
So the principles he articulated in Hensley are the logical extension of that critique. Principle 1, no immunity without constitutional text or federal statute. Okay? And the application in this case, Section 1983 contains no immunity. It states without qualification. Okay? That every person under the color of statute subjects any person to the deprivation of any rights shall be liable to the party injured. The word shall be liable are absolute. There is no constitutional provision and no federal statute that grants qualified immunity to Officer Delancey. Under Hensley's first principle, qualified immunity cannot exist in this case. Again, inclusio unias et exclusio authorius. The inclusion of one thing is the exclusion of another. Congress included liability and it excluded immunity. It's straight up. Principle 2, judge-made defenses apply only when the actor was doing what the government authorized. Okay? The application to my case. The city of Hood River never directed, authorized, or requested Officer Delancey to invoke, number 1, obstruction of justice. A charge that Delancey admitted under oath does not exist in Oregon. Number 2, arrest a parked motorist without asking for his identification. Did you ask Mr. Wilson for his name? No, I didn't. 3, seize a citizen's cell phone without a warrant in violation of Riley versus California. Or 4, use force against a cooperative individual with a prosthetic limb who was asking for badge numbers. Delancey acted entirely outside of the authority granted to him. Under Hensley's second principle, no judge-made defense can shield him. The city cannot confer immunity for conduct it never sanctioned. Principle 3, Congress knows how to write immunity when it wants to, and it did not do so in Section 1983. Hensley noted that, quote, Congress knows full well how to make its interpretation to preclude private liability known. Citing as specific examples of explicit immunity provisions Congress has enacted in other statutes, right? Because we have 42 U.S.C. Subsection 233 AG, which is immunity for federally funded health center employees. Or what about 50 U.S.C. Section 2783B, which is immunity for atomic weapons testing contractors. They know how to set immunity. Application to this case. Congress enacted the Westfall Act, 28 U.S.C. Section 2679, to immunize federal employees. Congress enacted the Foreign Sovereign Immunities Act, 28 U.S.C. Section 1602, to immunize foreign sovereigns, right? Congress enacted the Federal Tort Claims Act, 28 U.S.C. Section 2671, to govern suits against federal government. In every instance where Congress wanted immunity, it wrote immunity. In Section 1983, Congress wrote the opposite, shall be liable. The magistrate judge cannot read an immunity into a statute that Congress deliberately chose not to include. As Justice Scalia observed in a different context, quote, we are governed by laws, not by intentions of legislatures, unquote. Oh my Jesus. The law of the Section 1983 says shall be liable, period. Principle 4, courts cannot extend judge-made defenses beyond their narrow original scope. Principle 5, no immunity for conduct the government never authorized. And so again, the magistrate judge's qualified immunity analysis is built entirely on post hoc rationalization that the record itself refutes. And then we're going into more arguments there.
Damn, I don't understand something.
What's up,
How in
Machi?
the world can Congress enact immunity, like any kind of broad immunity in any kind of way, that Congress can make no law that abrogates the Bill of Rights, for instance? You know, immunity, it seems, I don't know how it's constructed for the nuclear people or the healthcare folks. I'm not sure how it was constructed. If it was narrowly construed, you know, but if there's substantial breach of someone's Fourth or Fifth Amendment rights, it doesn't matter what Congress says, is what I'm saying. And I don't understand how they can put immunity in there
I
for
mean,
certain things.
when they do, it gets on certain depths of why they've allowed the immunity to occur. But again, the whole point is when they have immunity, they will write it in place. That's the
Fair
basis of
enough.
it, right? That's the bigger side here, but they
I
haven't.
get
Okay, so
it.
the
Yep.
last little bit in this memorandum on the Hensley versus Floor that I brought forth and is part of the record because it was granted. Of course, it was very long. The defense ended up trying to move for a motion to strike to get this completely struck because they didn't want this on the record at all. They were serious about striking these pleadings, both the objections and in this memorandum. They didn't want it on the record because they knew how destructive it was. It was granted though, okay, and it is a part of the record, okay, for the appellate court if we need to go to the appeals. Now, the last little bit of this memorandum, though, that was in support is the Constitution and the federal rules of civil procedure strictly limit a judge's role, and this is very important. I need y'all to remember this when y'all are going through summary judgment, okay? The Constitution and the federal rules of civil procedure strictly limit a judge's role at summary judgment, all right? Now, just quickly, what I want to let y'all know is that you want to know how they've made errors here in Hood River. I have a federal lawsuit in Washington. Okay, my judge in Washington for Washington State Patrol used to be a federal prosecutor. Okay, all right. She's doing everything great. I'm talking about she is phenomenal. She is doing great. I can see the differences between her and them over here on this side, and they are pretty big. Okay. She's doing really good, bro. That's all I can say. I can see the differences between them because, you know, this judge over here is most definitely making sure that everything's going by the rules, the scheduling order, that the requirements are being made as far as her scheduling order is concerned. And then, which we'll get into here in a second, how the judges over here in Oregon are not. And they're just allowing essentially them to do whatever they want while violating the actual scheduling order and reports that are required or were required by a certain deadline to give in, which they just never gave in. Okay. So again, when the material facts are disputed, the judge's task is not, again, when material facts are disputed, the judge's task is not to decide which version is true, but only to determine whether a reasonable jury could find for the non-moving party. Can someone else explain this one to me? I want to get some explanation on y'all's comprehension of this here.
It still sounds like an opinion whether a reasonable jury could find. That sounds like it's still able to be the judge's opinion. I hate to say it.
Yeah.
Unless there's a dispute. So Cam's raised multiple disputes, multiple direct defects, like he said, it's in the record. So it's on the judge. Like you read out a sentence that judge said earlier. She read through and saw no genuine dispute or whatever she said. Like her putting that right there on the record is going in my next filing.
The judge's job is not to interpret the facts. That is the jury's job. The judge's job is to interpret the law as the facts apply. She cannot assume the facts.
Nevertheless, they put that language at the very end that a judge, I don't know if it's comma separated or if there's an or there, but it's that, and that a judge finds could reasonably be determined by a jury. They did put that language in there. I don't know the full context.
Go ahead, Aaron. I want to hear what you guys say too.
They're not there to say whether it's true or not. They're there just to see if there's a conflict, and that's it. And if you don't agree with them, then they pass it along to the jury, which they did not do.
Quote, at summary judgment stage, the judge's function is not himself to weigh the evidence and determine the truth of the matter, but to determine whether there is a genuine issue for trial. That didn't happen with me. The judge's decision to resolve disputed facts in the defendant's favor is what she did. And to do so by declaring that no contradictions exist when the officer's own testimony proves they do, is a violation of the constitutional separation between the judicial function and the jury function. The Supreme Court has emphasized this limitation with particular force in Section 1983 cases. Courts may not resolve genuine disputes of fact in favor of the party seeking summary judgment. You can't resolve. What? Can someone read this? Someone else read this for me, because apparently I'm confused. Apparently I'm the dummy here. Can someone else please read this out loud for me, please?
Courts may not resolve genuine disputes of fact in favor of the party seeking summary judgment. And that happened to me too with my cars. I'm just throwing that out there.
Am I wrong here?
Sean's got glasses. I swear it says Cam's an idiot. I'm joking.
So here we go. The Ninth Circuit has echoed this mandate in Blackenhorn versus City of Orange, reversing summary judgment where the district court improperly weighed the evidence in an excessive force case. Well, that's one of them, but we're going to get one that's actually way closer to mine, almost exact, to be honest. The magistrate judge crossed that line. This court must pull the case back to the correct side of it. Furthermore, the pro se status of the plaintiff demands that this court construe his filings liberally and afford him the benefit of every reasonable inference. Pro se pleadings are to be liberally construed. A document filed pro se is to be liberally construed. And the pro se complaint, however inartfully pleaded, must be held to less stringent standards than the formal pleadings drafted by lawyers. This magistrate's judge failure to credit plaintiff's evidence and to view the facts in his favor is doubly erroneous when applied to a pro se litigant. Okay? So in my prayer for relief, of course, I'm asking first, the original unadulterated text of the Civil Rights Act contained the notwithstanding clause that explicitly abrogate the state law immunities. The magistrate judge applied a doctrine that Congress itself prohibited in the statute's original text. Second, the Supreme Court's decision in Henson versus Floor establishes 5 governing principles that categorically preclude qualified immunity for the conduct. Third, the officer's own sworn depositions and testimony contradict the judge's magistrate's factual findings at every critical juncture. She didn't even include obstruction. Right? So accept and consider this, apply the 5 principles, apply the original text, reject the magistrate's findings, deny defendant's motion for summary judgment, set this matter for trial. Okay? So that's what I brought forth in support of the objections to her factual findings, right? Okay, so we're not going to move there yet. We're going to move to the dismissal. All right, so this one's next. So this week on the 6th, okay, we finally got the federal judge to make her decision. Now, bro, she used to be a Supreme Court justice. This is what's tripping me out. Let me show you who she is. Let's actually, before we read her thing, let's show who she is, okay? Because I really thought, I mean, I had never looked her up until after her decision. I didn't want to have any, I didn't want to have any viewpoints here. I just wanted to, but let's take a look. Adrienne Nelson. Okay, this is her.
As we continue to face a country divided over many issues, the ABA encourages the legal profession to lead the way in promoting civics.
Now let's see her TED Talk. She actually did a TED Talk in Hood River at the Mount Hood.
And actions with your open hearts and minds. A, act in a respectful way. Tap into the humanity of everyone who comes before you. K, keep judgments out of what you do. Resist that temptation. Resist that natural inclination to step back. Lean in. E, engage in a way where you can create bonds and develop solutions. Our world is dependent upon it. Put all that together. A-W-A-K-E, it spells awake. I want you to stay awake. I want you to stay awake because our collective conscience.
So she did a TED Talk out there at Mount Hood, at Hood River, in Hood River.
Dude, no one gets a TED Talk with lying, just so you know.
I wonder the ties there. Interesting. I'm not going to rule against the city that I went and spoke in.
You should bring this up as a conflict of interest right there.
Very interesting.
Maybe, but I also wonder if she's putting anything out there that might contradict her stance on here.
She's a woke
probably
loser.
puts out one stance, but
Hey.
privately holds another.
Woke loser. Huh?
They're all woke losers.
Chill. All right. So, this is going to be her order that we received on the 6th. Okay. So, United States magistrate issued findings, right? Recommending that this court grant defendants City of Hood River, right? City of Hood River. Oh, I've been out there in Hood River. I remember my TED talk. All right. We'll keep going, though. Officer Delancey, motion for summary judgment, 66-page document. Plaintiff also separately filed a declaration in support thereof. Motion for leave, file excess pages. Same day, defendants moved to strike the plaintiff's objections as untimely. Plaintiff responded in opposition to the defendant's motion to strike, and defendants responded in opposition. Objections. The matter is now before this trial. For the reasons stated above, the court adopts the FNR in full. In full. So you didn't find no issues in full, and finding that adoption of the FNR in full is appropriate. Look at this. Regardless of the arguments made in the contested materials. Regardless. In full. Regardless of the materials. Exercises discretion to grant the plaintiff leave to file. So she granted my motion for leave to file excess pages. Accordingly, the defendant's motion to strike plaintiff's objections is denied. So she denied their strike. A district court judge may accept, reject, or modify in whole or in part. When magistrate judge issues the findings and recommendations on the dispositive matter, a party may file objections. The court shall make a de novo determinations of the portions of the report. The district judge may determine. In this action, plaintiff alleges the violations. The discovery deadline and dispositive motions deadline were eventually extended. Summary judgment. The parties briefed the motion. Okay, cool. The court extended the plaintiffs. We already know this. This is all just, preliminary administrative stuff. And file the declaration. File excess pages, seeking leave nunc pro tunc to cure any potential procedural defect. Great. All that good stuff. Plaintiff objects to the FNR are extensive. Plaintiff asserts that the FNR erred in finding that the defendant's facts are uncontroverted by the evidence in the record and by resolving disputes of material facts in favor of the movement. Plaintiff asserts that 6 of the FNR's findings are contradicted by evidence of the record and identifies 14 purported disputes of material fact that should have precluded a summary judgment. Plaintiff then raises 19 specific objections. Okay. Court has thoroughly reviewed the court and the filings pertinent to the issues and now before it and concludes that the plaintiff's objections are without merit. Without merit. The court has thoroughly reviewed the record and filings pertinent to the issues now before it and concludes that plaintiff objections are without merit. Everything that I brought forth is without merit, huh? Interesting. Plaintiff's supplemental memorandum raises 2 non-repetitive arguments. First, the codified text, okay, and the scrivener's error is an improper source of qualified immunity. Second, the Supreme Court's decision in Hensley, which was issued after, okay, good. After the FNR, impliedly abrogates the qualified immunity. Okay, well, she did bring it, so I thought she said it was before. Okay, so good. Abrogates the qualified immunity defense. Both arguments fail because binding authority must be followed unless and until overruled by a body competent to do so. Now, guess what? Just because this Hensley versus Floor was brought after the FNR, it was brought before you gave your order. Doesn't matter if it was brought after her FNR. It was brought forth before your order. So why aren't you taking it into consideration then? Interesting. Because binding authority must be followed unless or until overruled by a body competent to do so. So what are you telling me? Both arguments fail because you're unable to do anything about it right now? Is that what you're saying? Neither of the authorities cited by plaintiff abrogate the Supreme Court's qualified immunity doctrine, which continues to be binding law. Okay. Then she's bringing in Zorn versus Linton, which is new as of this year, 2026. Upon the de novo review, this court agrees with the FNR and literally dismisses my case. That's it. That's all I got. On everything that I brought forth, requesting that the federal judge do what's right here and really give her opinions based on it, she didn't mention the objections. She didn't mention nothing. She didn't come through and say, you know what, I actually find an issue here because it wasn't a traffic stop or that you didn't bring forth the objections or anything. It's just blanket, I agree with them, and that's it. All you brought forth was my cores of the arguments, which is Hensley and then the other, but still you just rejected everything. You literally rejected everything. You didn't find any issues in relation to that she moved in favor of the moving party when she's supposed to move in favor of me, the non-moving party. So let me ask y'all now, where do you think this is and where am I going? Let's ask that.
59E. Motion to amend your complaint. Not amend your complaint, amend the judgment.
Amend the offer, or the order, excuse me, right?
Yep.
So we have the plaintiff's Rule 59E motion to alter or amend the judgment, okay? We're asking for an oral argument as well to get in there and actually speak for once in the federal courthouse, right? I want to get in there and I want to start talking and arguing this out, okay? Motion to alter, all right? Pursuant to the federal rule, it's not over. People say, it's over, you're dismissed, you can't file nothing else. You're wrong, okay? Cameron still got a plan. Plaintiff Cameron Wilson, a living man standing in proper persona, respectfully move this honorable court to alter or amend the judgment and order denying plaintiff's motion for a court-ordered mediation as moot, right? Because what ended up happening is that she put in a report through her case scheduling order to do in a court-ordered mediation. It was never filed. They filed a summary judgment and acted as though this court-ordered mediation report was still not supposed to be filed. According to the rules, it's still supposed to be filed. They can't just not, just because you filed summary judgment doesn't mean you still don't have to abide by the court scheduling order and file a report that is required by the court. How does the judge, not say, you know what, you didn't file that? We have to stop all summary judgment until you actually file that because you haven't filed it. It's past the deadline. How y'all just gonna violate the rules? Right? So the relief 59E is necessary to correct the manifest errors of law, prevent structural injustice, and cure the court's failure to conduct the statutory mandated de novo review of the plaintiff's specific objections. Holding 59E relief is appropriate to correct clear error and prevent manifest injustice. So the judicial oath codified in 28 U.S.C. section 453 requires every federal judge to solemnly swear to administer justice without respect to persons and do equal right to the poor and to the rich, and to faithfully and impartially discharge and perform all the duties incumbent upon me. On August 6th, the court entered ECF number 70, adopting the magistrate's judge's findings and recommendation in full and granting summary judgment to defendants. The 3-page order is facially deficient, structurally flawed, and constitutes reversible error. By expressly disclaiming genuine de novo review, improperly resolving 14 genuine disputes of material fact, ignoring a structural due process violation regarding the mandatory alternative dispute resolution, and misapplying the qualified immunity standard under Zorn, the court has abdicated its ministerial duty. The Ninth Circuit has expressly admonished district courts from rubber stamping magistrate recommendations without adequate review, which is under CUSA versus Ramos, 2023 concurrence. This Rule 59E motion provides the court to the opportunity to correct its own manifest errors of law before appellate intervention becomes necessary. So it's like, I'm asking you to fix it before the Ninth Circuit goes ahead and reverses it, because I've got, and we'll go over the case. The court committed a clear error by expressly disclaiming genuine de novo review. Under 28 U.S.C. 636B1C, when a party files specific objections to an F&R, the district judge shall make a de novo determination of those portions of the report or specify proposed findings or recommendations to which the objection is made, right? The word shall creates a mandatory non-discretionary obligation. In ECF 70, the court states it adopts the F&R regardless of the arguments made in the contested materials. Interesting. Regardless, huh? So you didn't reply to them. Regardless of my arguments, you're just going to adopt it. Okay. This language is devastating judicial admission on the permanent record that the court did not conduct a genuine de novo review of the plaintiff's specific arguments. The Ninth Circuit has consistently held that boilerplate adoption of an F&R without addressing specific substantive objections constitutes reversible error. This one, I'm wondering if this one is the full and complete one that I actually did. It might not be. Maybe it is, maybe it's not. Maybe it's not the final one. Okay, but we'll read it anyways because it's given the basis. Let's see. Plaintiff filed 66 pages of meticulously detailed objections, identified 14 specific disputes of material facts, and raising 19 specific objections to the F&R's factual findings and legal conclusion. The court's conclusory dismissal of these objections in a single sentence concludes that plaintiff's objections are without merit. is the very definition of a rubber stamp adoption. It violates the statutory, this one ain't my final one, mandate of the 636B1C and denies plaintiff the equal right guaranteed by the judicial oath. Summary judgment is legally prohibited where genuine disputes of material fact exist. Credibility determinations, the weighing of the evidence, and the drawing of legitimate inferences from the facts are jury functions, not those of a judge. Furthermore, the Seventh Amendment of the United States Constitution preserves the right of a trial by jury in Section 1983 actions. The Supreme Court has unequivocally reversed lower courts that fail to view evidence in light most favorable to the non-moving party as summary judgment. Plaintiff placed 14 specific disputes of material fact on the record. The court resolves every one of these disputes in favor of the moving party without explanation. Without explanation at all. There's no explanation. The following genuine disputes of material fact viewed in light most favorable to the plaintiff as required by Anderson preclude summary judgment as a matter of law. Plaintiff was a pedestrian on a public sidewalk, not subject to a traffic stop. Okay? He was not operating a motor vehicle. He was not pulled over. Defendant's entire legal framework, traffic stop authority to control movements, order occupants back to the vehicles, and demand identification collapses if plaintiff was not a motorist subject to a traffic stop, but rather a pedestrian exercising his creator endowed right to exist on a public sidewalk. Stated basis for arrest, obstruction of justice, is legally invalid. At the scene, that's what he did. Plaintiff was handcuffed immediately after exercising protected First Amendment rights. Officers interfered with plaintiff's First Amendment right to record. The covered Venn theory is a post hoc rationalization. The courts committed clear error by ignoring the structural due process violation regarding mandatory ADR. And then the court's order, ECF 70, completely ignores plaintiff's pending motion for court-ordered mediation. On July 6, the court issued a scheduling order, ECF number 69, explicitly acknowledging the mediation motion and promising to set a briefing schedule once the pending summary judgment motion is finally resolved. This summary judgment motion was finally resolved on August 6th, and instead of honoring its own commitment, the court dismissed the case without ever addressing the mediation motion on the merits. Yeah, this is not the final one. Thereafter, on the same day, she entered denying because the case is dismissed. This constitutes textbook circular reasoning, petitio principii, okay? A logical fallacy that no court of law may employ as the basis for a dispositive ruling. The court dismissed this case without addressing the mediation motion, then used the dismissal itself on the sole basis to deny the mediation motion as mute. One cannot use a conclusion to justify the premise. The mediation motion challenged the procedural propriety of the proceeding to summary judgment without completing mandatory ADR. Mandatory. There's a mandatory ADR report or alternative dispute report that was supposed to be brought in that the court just ignored. We don't care about the rules that we set forth. We're going to allow them to disregard it. It compounds it. Moreover, ECF number 69 constituted a binding procedural commitment by the court to set a briefing schedule and under advisement deadline on the mediation motion after the summary judgment ruling. The court broke its own promise. As established in ECF 68, defendants violated the mandatory ADR requirements by failing to confer or file a joint ADR report despite the deadline being set and extended 3 times over 18 months. So they had 3 different extensions over 18 months and still didn't do it. Defendants filed their motion for summary judgment on the 6th, a full month before the final ADR deadline of September 5th. The court permitted defendants to bypass the mandatory ADR process entirely, then dismissed the case, then denied the motion challenging that bypass as mute. This sequence constitutes a structural due process violation of the highest order. The court misapplied the qualified immunity standard under Zorn versus Linton. The court dismissed plaintiffs' arguments regarding the abrogation of qualified immunity by citing Zorn. While Zorn reaffirmed the clearly established prong of qualified immunity in a specific factual context, paying compliance on a passive protester after warnings, it did not overrule the threshold requirement of Saussure versus Katz, which requires that courts first determine whether the facts alleged show the officer's conduct violated a constitutional right. More importantly, Zorn does not abrogate the summary judgment standard. Because the material facts of the seizure are disputed, the court cannot jump to the clearly established prong to grant qualified immunity. Zorn does not permit courts to resolve factual disputes at summary judgment, nor does it allow officers to rely on post hoc rationalizations to justify an unlawful seizure. Okay? So we've got that going on. This is not the final one. I know it's not. That I'm going to be filing, but this is the strong basis of where we are moving, or where I am moving into is the next step, okay? Before actually moving into an appeal in and of itself, right? Because the appeal is very important. If I have to go to an appeal, I'll go to an appeal. Ain't nobody tripping on that. Like, what y'all talking about? I'm down for that. There's no doubt, 100%, right? I am completely down to take it to an appeal. And the reason being is because of Rice. Let me see if I have it in here. I should have it right here. Yep, Tom Anatomy. Save this bad boy and then open it up. All right. No, let's open it up in the actual preview. All right. So actually, I want to get a couple of comments from y'all first off, as far as how y'all are viewing everything and what's going on.
So I got a couple procedural questions that just to open for the group for clarity, if I could real quick. So you're dealing with a magistrate, so you're in state court presently, correct?
Who, me?
Yes.
No. What has been done is when I first filed my suit, Nelson said, all right, for all the administrative stuff down low, I'm gonna let y'all go ahead and I'm gonna assign it to a magistrate judge to take care of all the administrative stuff until it gets to a point where I need to actually make a decision.
So you're dealing with an ALJ. In what level of court are you in right now?
I'm in the federal district court.
Oh, so you're already in the district court. Okay.
Yeah, I'm in the federal district court. She just allowed a magistrate to come in because maybe her caseload was a little bit too heavy or something like that. So she had a magistrate to come in and say, hey, go ahead and take care of all this administrative stuff and try and find something. But that could have been set from the jump. Once she read it, she could have been like, I'm going to need you to make this decision down low. I don't want to deal with this one. You know, I may have a conflict of interest here or something like that. So, yeah.
And so then for the trial de novo motion, you're basically, or de novo review, you're asking the magistrate to review your petition from the get-go, right? You're a re-review.
The de novo is supposed to be up to the federal district judge to actually do a full review of everything and then make a decision. Yes, correct.
So it leaves the magistrate and goes to the assigned judge then.
Yeah, so the magistrate made her findings and recommendations, right? What she made the recommendations that it should be dismissed and qualified immunity should be granted. She sends it up to the federal judge. I did an objections though to her. Then the judge has to do a de novo review completely, do a whole de novo review completely, entirely of everything, and then make a decision. But the only thing here is that she stated, regardless of the arguments, I'm not going to address those, and I'm just going to, take the judge's recommendations in full. So it's almost like,
I'm missing something, guys. She's how if she's at the federal level, how is she an ALJ, administrative law judge? Minor point, but
yeah, she's doing the administrative side of everything on the lower end to then give full authority up to the federal judge to make the final decision. So it's essentially, when you're doing your federal cases, it's really, the judges are honestly, to be honest with you, up until you get to the point of where you're doing a default judgment or a summary judgment or something like that, they're really just making sure that everything goes according to the case scheduling order. They're really just making sure that, because most of the communication is between you and the actual other party. So, I don't think I'll ever allow for a magistrate judge to take care of my case again because of this situation. But, I can see why they do it because, to be honest with you, they're just making sure that everything goes in alignment up until you get to a point of where there actually needs to be the judge to make a decision, right? It's really just saying, okay, yep, you're going by the timeline, make sure that this is good. And the majority of the, communication is directly between you and the defendants. And there may be some times where you need to file, something to say, like, okay, they made the reply, so I'm making my reply. They make another reply. Okay, can I actually, now I got to file. Can I make another reply? Can I request for a reply? Or can I amend my complaint? I got to ask for permission, or can I ask for an extension of time? So a lot of the stuff initially, as you're starting off, is just administrative, right? It's not really too much of we're making cold case decisions because, again, everything is supposed to honestly be made, as far as decisions are concerned, with the jury. Right, we're not going to a bench trial here, okay? And so that's why it's pretty substantial that these decisions were made, finding facts in favor of them as far as the moving party when they're supposed to be looked at in favor of me when there's a genuine dispute of material facts on the record. I mean, it's very clear.
So then procedurally now it's going to go back to the judge for review de novo.
No, it already did.
It already did. Okay, so now they're going to review it, and then the judge is going to make a final decision on the summary judgment.
She already did. That's what we just read.
Okay, so that was from the actual assigned judge, not
federal judge. Yep.
Got it. And so now you're going to ask for the Rule 59 basic motion for reconsideration. Is that
it's a amend or leave to change out some of the mistakes that she made? Yes, most definitely.
So basically, it's a post judgment prayer for relief, basically.
Correct.
And so then let's just say hypothetically you don't get the relief you're requesting. Where does the appeals go to? Does it goes to the state appeals court, or then do you have to go to the state Supreme Court?
The ninth district, baby. Let's go.
So if you're in district court now, you're going from a district judge to the appeals court in the same district. Is that correct?
Yep, Ninth Circuit.
Federal district.
Federal district, right. And
Right.
so this would be outside of the
State.
federal, it would be outside but it would be the ninth district as a whole, right?
Yeah, the Ninth Circuit. Yep.
Ninth Circuit, copy that.
Mhm.
And I'm trying to clarify this for my own knowledge, but also too for our group, because the point that I would like to make is, this is, I think, where we are as a movement and as a group, where we have to be taking these cases to the higher courts to establish case law, okay? And this is where we have to not be afraid and not get shut down. I apologize if my vocals are too loud.
No, you're good.
No, you're good.
Cool, thank you. So, because if we get these lower courts are going to shut us down over and over again. Okay, you've seen how they've treated Cam, and they obfuscate facts and they omit facts and they rush to judgment. I think this post hoc ergo hoc thing is so applicable because they're making assumptions based on facts that they haven't even considered, right? So they're saying causation without actual facts. They're jumping the gun basically, right? And they're doing this intentionally because they want to shut you down and not allow you to get to those higher courts and get.
Yeah, but it's not always like that though. Like I said, my judge over in Washington State Patrol, she's doing amazing, bro. Like literally doing amazing. Like I think not only do they understand that she is moving more towards me, but I can definitely feel that she's moving more towards me. I'll give you an example. I had to file an errata to make changes to ECF 49, which was essentially my cross motion, my opposition to their summary judgment and cross motion for partial summary judgment on my behalf. And I had a couple things in there that I made errors on, and I did a motion for errata to make those changes. And it was just 2 changes, right? And instead of her just saying, okay, I accept those 2 changes that you're making, she literally said, you know what? Why don't you just take ECF 49 and make all the correct changes that you need to make? She didn't have to do that. She didn't have to do that. And I know that's a signal to me and to them. I'm kind of moving in favor of homie, right? Just this yesterday, I think she did. She put out an order yesterday saying, y'all need to give me y'all's the facts that are not undisputed whatsoever, right? Well, I've got 24 of them, and I had to send over an email, and I'd already drafted it up and sent it over to them. And they're not, I know they don't want to actually say that these facts are not undisputed, but if you do say that they're undisputed, you look like a liar because it's all on the record already, right? So you have to actually agree to them, because if you don't, you look like, you look very bad if you don't agree to just these facts that I've brought forth to them. And I know they don't want to, but they have to. It's on the record, right? So everything's moving in favor for me heavy on WSP side. Heavy.
And that's at the state court level, correct?
No, we're all federal court. Everything's federal court.
All federal court. Got
Yeah,
it.
everything's
Got
federal
it.
court. Yeah, I don't do no state
Clearly,
torts.
There's going to be judges on both sides of the aisle that are going to be pressed for constitutional amendments right now that'll be ruling in your favor, and some of them won't. I mean, that'll just be this woke fucking narrative that'll be pushing for their power and control, and the constitutional avoidance doctrine.
Yep.
And so it's a crapshoot, man. So yeah, I mean, even in my case with the tribe, they said, "Oh, we're dismissing because there's no jurisdiction or there's no facts stated that support my case." But at the same time, it says in there he told us about all these federal laws that they're violating, and the first thing that they're supposed to judge on is whether there's any violation of law. It's like they just dismissed it without prejudice. It's like, okay, so now we're up to the next court.
Yeah, it seems Oregon's a little bit more difficult. There's no doubt.
Yeah. Damn right.
I can tell.
Well,
for
and
sure.
if it's without prejudice, that means you can come back at them, though.
No, I think it was with prejudice. Yeah, they don't want me going back to the tribal courts, so I'm up to federal now. But
And that's why I see me personally, I don't do no state torts. I'm going straight federal every time. That's where the power is, right? The
Yeah.
foundation is the Constitution. Why are you going to go to the state? The state, I mean, yeah, the state does have more protections and then more statutes that you can apply. Like if I would have went with a state tort, I could have hit for like, misconduct, police misconduct, and all the smaller stuff as far as statutes are concerned. But I want to get to the depths of it, the deeper side, which is the foundation in the Constitution, right? Okay.
Yep.
So what I've built and I've put in the Discord for everybody is this strategic litigation masterclass on the anatomy of the federal summary judgment dismissal. And it's just giving more details as far as an education is concerned. This one's pretty long. I think it's like 50-something pages, 54 pages on the deeper side of what you can understand, where I'm currently at, how to utilize it. It's literally giving all the education. And I wanted to give this to y'all because, again, no matter what you're going through, I'm kind of before everybody in this federal stuff, other than Jack. Jack's somewhere very similar to me as far as where we are standpoint. I think he's actually a little bit ahead of me in this regard. But both of our situations are definitely being able to give y'all some understanding of what may happen and how to properly prepare for it, right? Because I'm sure a lot of people didn't know, oh, if it's dismissed, what am I supposed to do? Just go straight for appeal? No, you can hit for the 59E and get them to amend or alter the mistakes that they've made once you've called it out, right? You have to call it out though, right? Just like you have to invoke, just like you have to rebut, you have to bring it forth. Let's see. So it is valuable because, my case, in and of itself, because it presents in the concentrated form nearly every doctrine a serious 1983 litigator must master. The allocation of functions between the judge and the jury. The distinction between a disputed fact and a material disputed fact. The interaction between Rule 56 and qualified immunity. The objective probable cause rule of Devenpeck. First Amendment retaliatory arrest doctrine in Neves and Gonzalez, video evidence under Toland, Scott Axis, the magistrate judge's review under 28 U.S.C. 636b1, the narrow office rule of 59E, the preservation, the harmless error, the alternative grounds for affirmance, and the transition from district court advocacy to appellate advocacy. The central lesson is more refined than disputed facts defeat summary judgment. That slogan is incomplete. The operative proposition is a federal court may grant summary judgment notwithstanding many factual disagreements if none is both genuine and material to a dispositive legal issue. But where the outcome depends upon choosing between competing evidentiary versions of a material historical event, weighing credibility, or drawing a reasonable inference against the non-movement, Rule 56 forbids the court from performing the jury's function, which is exactly what they did with me. That distinction is the intellectual center of this current post-judgment strategy. The case also teaches an equally important lesson in candor. Several theories preserved in the earlier objections are weaker than the Rule 56 theory now foregrounded in the Rule 59E motion. The fruit of the poisonous tree theory collides with the binding Ninth Circuit authority holding that the exclusionary rule generally does not apply in Section 1983 civil damages litigation. The Miranda theory is evidential at most and cannot be treated as conclusive proof of arrest. The ADR theory is materially weakened by the District of Oregon, LR 16-4I, which states that ADR ordinarily does not stay the action. The historical attack on qualified immunity may be academically significant, but Hensley versus Corp did not overrule qualified immunity. And while Zorn versus Linton decided in 2026 reinforces the Supreme Court's demand for highly fact-specific, clearly established law. None of these concessions destroys the appeal, they sharpen it. He who distinguishes well teaches well. So, the advanced litigator does not defend every prior sentence with equal intensity. He ranks issues. He abandons unnecessary overstatement. He preserves broader arguments where appropriate, but builds the appeal around the few propositions that are simultaneously preserved, record-supported, material, and governed by favorable controlling law. So, of course, the litigation chronology, we already know my docket. You can check it out if you want. But you got the complaint that was filed, the initial scheduling order, the public docket reflects discovery, and a joint ADR report timetable, okay? This begins the procedural history later invoked in the ADR dispute. Service was completed. We have our whole little docket here brought forth, right? What case terminated actually means. When you get a case terminated at the end, it doesn't mean it's terminated to where you can't do anything whatsoever. The entry of a the entry of judgment under Rule 58 and the termination of the civil docket does not strip the district court of authority to entertain the post-judgment motions authorized by the federal rules. Rule 59E exists precisely because judgment has already been entered. A timely Rule 59E motion asked the district court to alter or amend that judgment. Okay, here the judgment was entered on the 6th. Rule 59E permits filing no later than 28 days after the entry. So you got 28 days. Once you file this Rule 59E, it also actually puts a stay on the until we get a decision, puts a stay on the appeal. Okay, so on a simpler calendar computation, the deadline is September the 3rd. And Rule 6B2 does not permit the court to enlarge Rule 59E's deadline. The strategic implication is elementary but indispensable. The motion is post-judgment by design, and the docket's terminated label does not defeat it. The order's moot important procedural feature is that this is one of the strongest good facts in the procedural record. Defendants asked the district court to strike the objections as late in excess of the local page limitation. Judge Nelson declined that strike. She granted my motion for leave to file the excess pages and denied the motion to strike. She then expressly summarized the scope of the objections, 6 asserted contradictory findings and the 14 asserted disputes of material fact and 19 specific objections. That does not mean she accepted their merits. It means something different and strategically useful. The objections were before the district judge. Were recognized as such, and were rejected on the merits rather than erased from the record. The appellate preservation question is therefore stronger than it would have been had the objection simply been stricken. So then we have on to the Rule 56 governing architecture of the summary judgment. Now, Rule 56 is not a command to rule for the non-movement. A common formulation says that summary judgment, the judge must rule in favor of the non-moving party. That is imprecise, right? Rule 56A authorizes judgment when there is no genuine dispute as to any material fact, and the movement is entitled to summary judgment as a matter of law. The non-movement receives the benefit of favorable evidentiary construction, not an automatic merits victory. But the doctrinal sequence is to identify the government governing substantive law, determining which historical facts are material under that substantive law, ask whether the admissible evidence or evidence capable of being presented in admissible form creates a genuine dispute over those facts, view the evidence and draw reasonable inferences in favor of the non-movement, which is me, do not weigh credibility or choose among competing reasonable versions, which they did. When it wasn't a traffic stop, they said it was a traffic stop. Nonetheless, 6, disregard a version that is so blatantly contradicted by objective record evidence that no reasonable jury could believe in, and then they apply the law to the non-movement favorable version of genuinely disputed material facts. The Tolan-Scott axis, why video evidence can either save or destroy a claim. The most useful conceptual pair for this case is not Tolan alone. It is Tolan together with Scott versus Harris. Because the Tolan principle is that a court errs when, at summary judgment, in a Section 1983 qualified immunity case, it fails to credit record evidence contradicting key factual conclusions and thereby resolves disputed issues for the movement, which they did. The Scott limitation. When one's versions of events is blatantly contradicted by objective video evidence such that no reasonable jury could believe it, the court need not adopt that version merely because it is offered by the non-movement. These authorities create a disciplined method for body camera cases. The appellate brief should not merely say the video supports me. It should isolate timestamps, time transcript pages, camera angles, audible commands, gaps, and ambiguities, and then ask whether the video conclusively resolves the disputed event or merely permits competing inferences. Where it merely permits competing inferences, Tolan governs. Where it utterly discredits one version, Scott governs. So the Operation Wise Dome teaching point here would be that the body camera is not automatically objective truth. It is objective evidence with a field of view, audio limitations, temporal sequencing, and interpretive boundaries. The advanced question is whether it conclusively eliminates a reasonable jury's ability to accept the non-movement's version. Now, a factual disagreement does not preclude summary judgment merely because it exists. The disagreement must affect the outcome under governing law. Thus, a strategic appellate preservation should never stop at facts X was disputed. It should state disputed historical fact, the governing element, and the outcome if plaintiff's version is credited. You're giving everything. For example, whether the VIN was first mentioned after handcuffing is not necessarily material by itself. What matters is whether before the seizure, Delancey had already observed or objectively known facts that supplied lawful grounds. If the transcript sequencing permits a jury to infer that the covered VIN condition was not observed until after handcuffing, the timing becomes material and the material to the objective probable cause analysis. If disputed evidence instead establishes procedure observation, then the later verbal mention is merely chronology of speech, not chronology of knowledge. This distinction is central to the perfected Rule 59E theory. Now, plaintiff's ECF 57 quoted the FNR as stating, "I find no contradiction of the defendant's facts by the evidence on the record." Plaintiff's objections then treated that proposition as the load-bearing premise of the recommendation and attempted to disprove it with deposition testimony, and the body camera transcript. Now, the important appellate question is not whether the sentence was rhetorically broad. The question is whether the recommendation actually depended upon treating disputed material historical facts as undisputed. ECF 57 placed 14-item matrix before the district judge. For educational purposes, the matrix should be separated into 3 classes: potentially dispositive, factual disputes, supportive contextual disputes, and propositions that are not truly factual disputes at all. Right? The traffic stop, number 1. Plaintiff preserved record theory. The officer stopped a different SUV, right? Wilson was already parked. Delancey testified contact did not occur while Wilson was operating the vehicle, and called it not a traffic stop in the traditional sense. Strategic appellate assessment, potentially material, but only if linked to the legal authority available at the actual moment of seizure. The label itself is not dispositive. All right, then we have 2 stated obstruction bases. FNR omitted Delancey's contemporaneous statement that he was detaining Wilson for obstruction of justice, and Delancey later acknowledged that exact title is not an Oregon statute. Important evidence, but not independently dispositive, because Davenpeck makes the Fourth Amendment inquiry objective. The Venn timeline. Handcuffing appears at transcript page 4, Venn first verbalized at page 7. One of the strongest issues if the evidence permits a jury to infer that the covered VIN was first observed, known after the seizure. Then to number 4, movement. FNR said Wilson attempted to walk away. Plaintiff says he turned Junt to request badge information. Junt called the conduct non-threatening, potentially material to flight resistance, force, and causation in retaliation. The identification. Delancey testified he had not asked Wilson his name before handcuffing. Transcript concludes, "You haven't even given me a chance." Potentially material if non-compliance with an identification request was used to justify escalation. Subject number 6, order versus request. Plaintiff's preserved record theory. FNR described officers as asking Wilson to return. Delancey testified he commanded rather than asked. This strategic appellate assessment is contextual. It helps locate the seizure and show coercive authority, but wording alone is unlikely dispositive. The badge numbers. FNR said officers provided badge numbers. Plaintiff contends Junt had not provided his before arrest. Contextual material to retaliation, if temporal sequence is supported. The phone seizure. FNR characterized placement of phone as preserving recording. Plaintiff notes recording stopped. Potential claim issue, but requires causation evidence. The fact that recording stopped does not itself prove officer interference. Well, it does in a sense, but you have to prove it, right? Cooperation. FNR described plaintiff as fully cooperative. Delancey called him cordial. Plaintiff argues obstruction therefore lacks basis. Useful to force retaliation, but cordial does not automatically negate all lawful grounds for detention. Citations. FNR said released with warnings. Transcript says no citation was issued. Mostly contextual. Absence of citation does not retroactively erase reasonable suspicion or probable cause, but they had neither, right? The retaliation. FNR found no casual evidence. Plaintiff points to seconds between badge request and handcuffing. Potentially material. But temporal proximity alone may be insufficient if probable cause exists, where there was none, but Neve Gonzalez must be confronted. The prosthetic limb. Potentially relevant to force, right? We have equal protection. FNR said Wilson was the only person who tried to exit. Plaintiff says he was already outside before contact. Factually relevant, but legally difficult. A valid comparator and intentional differential treatment remain necessary. And then qualified immunity. Matrix states officers violated clearly established law, not a factual dispute. Qualified immunity is a legal conclusion dependent on assumed historical facts. It should not be counted as fact on appeal. Now, this ranking illustrates a critical appellate discipline. The Ninth Circuit does not need 14 reversible disputes. One truly dispositive dispute is enough. Conversely, 14 immaterial disagreements do not defeat summary judgment as well. Now, Judge Nelson's order did several things that must be represented accurately. First, it acknowledged the governing statute in Rule 28 U.S.C. 636b1c and Rule 72b3, requiring de novo determination of properly objected to portions of dispositive recommendation. Second, it expressly acknowledged the breadth of plaintiff's objections, including the 6 alleged contradictions, 14 asserted disputes, and 19 objections. Third, it stated that the court had thoroughly reviewed the record and the filings pertinent to the issues and concluded the objections were without merit. Fourth, it separately addressed the 2 non-repetitive supplemental qualified immunity theories, the historical notwithstanding clause theory, and the contention that Hensley impliedly abrogated qualified immunity. It rejected both because lower courts remain bound by existing Supreme Court qualified immunity precedent unless and until overruled by competent authority, citing Hart versus Mansanari and Zorn versus Linton. Fifth, it stated, upon de novo review, this court agrees with the FNR's findings and recommendation, adopted it in full, granted summary judgment, and dismissed the action. Now, a strategic brief should resist the temptation to argue that the 3-page adoption order necessarily proves the absence of de novo review. That's not going to be my main argument. Section 633 requires a de novo determination. It does not necessarily require a de novo evidentiary hearing or a paragraph-by-paragraph written response to every objection. That's coming out of United States versus Raditz. Or that it distinguishes determination from hearing, and Ninth Circuit authority likewise does not impose a universal requirement that the district judge write an appellate-style opinion addressing every objection individually. Thus, the stronger argument is substantive. Even accepting the district court's representation that the de novo review occurred, the final judgment remains reversible if the FNR adopted in full contains a material Rule 56 error that is demonstrable from the record. That is the better way to bring forth the errors that were made, right? This is why the perfected Rule 59E motion moved away from accusing the court of expressly disclaiming review and toward identifying the Rule 56 methodology allegedly incorporated into the judgment. Now, the order says adoption is appropriate regardless of the arguments made in the contested materials. Read that context. The language appears in the discussion of whether to permit the oversized late objections and accompanies the decision to grant plaintiffs leave and deny defendants' motion to strike. It should therefore not be quoted as though Judge Nelson admitted that she refused to consider the plaintiff's arguments. The same order later says she thoroughly reviewed the record and conducted a de novo review. That sentence may still be rhetorically notable, but it is not the strongest appellate point. The strongest point is whether, despite professed de novo review, the court adopted factual predicates that cannot be reconciled with the required non-movement favorable construction of the record in and of itself. Let me do one more pause. I definitely got to take a restroom break. Hold on 1 second. Now we've got the 4 core Rule 56 issues now worth building around. The core issue is the pre-seizure VIN chronology. The perfected Rule 59E motion correctly reformulates this issue. It no longer argues that the VIN was conclusively discovered after seizure merely because it was first verbalized later. It argues that the record, construed in plaintiff's favor, permits a reasonable jury to make that finding. The preserved chronology is: handcuffing appears at transcript 8, page 4. The VIN is first discussed at transcript page 7. Delancey's deposition, as cited by plaintiff, described the VIN as reasoning for the detention. The FNR relied on the covered VIN and lack of plates as objective justification. The governing doctrine has 2 levels. Level 1, probable cause timing. Under Beck v. Ohio, probable cause is assessed at the moment of arrest based upon the facts then known. Later acquired facts cannot retroactively become facts known earlier. Now, what's important about this is they literally, I'm traveling through Hood River doing under 20 miles or 25 miles an hour, and then you have someone behind me doing 40 miles an hour, and they pull them over, which could seriously impose a safety risk to the public. Right? We're in the middle of the downtown Hood River. They literally let them go to then mess with me on an administrative level. Which one is more important, safety or administrative level? I would think the safety of the public is more important, but they literally just let that person go and then came to attack me. Level 2, objective offense theory. Under Devenpeck versus Alford, an arrest does not become unconstitutional merely because the officer announced the wrong offense or subjectively relied on an inept label. If objective probable cause existed for some other offense based on facts known at the time, the arrest may be valid. but there wasn't. That's the whole point here. The appellate issue, even though he stated something wrong, there still was no probable cause that existed of a crime, right? The appellate issues, therefore, should be framed as a knowledge chronology, not an offense named chronology. The appellate formulation, construing the evidence in, and this is again appellate formulation, construing the evidence in Wilson's favor, could a reasonable jury find that the facts later invoked to establish objective justification, particularly the covered VIN condition, were not observed or known until after Wilson had already been seized? If yes, could the remaining pre-seizure facts independently justify the scope and manner of seizure? There is an additional statutory nuance that deserves serious attention as well. ORS 819.430 criminalizes knowing possession of a vehicle with a removed, defaced, covered, altered, or destroyed VIN for the purposes of concealing or misrepresenting the identity of the vehicle component. ORS 819.440 separately authorizes police seizure and inspection when an officer discovers a vehicle from which the VIN has been removed, defaced, covered, altered, or destroyed. A polished appellate brief must identify exactly which Oregon provision the FNR relied upon, distinguish criminal probable cause under 819.430 from vehicle seizure authority under 819.440, and avoid treating those provisions as interchangeable. All right. The statutory distinction can materially affect the analysis. Section 819.430 contains a purpose element. Okay, primary. What's the purpose here? Section 819.440 is an identification and disposition provision triggered by discovery of a comprised VIN. The appeal should therefore quote the exact FNR language and the operative 2022 statutory text, then connect it to the precise seizure challenged. Okay, you can't just be out here just, oh, you had a covered VIN, so that's a crime. No, there has to be a first underlying situation as well. All right, so then we got plaintiff's objections cite Delancey's admissions that Wilson was not operating the vehicle when contact occurred and that the contact was not a traffic stop in the traditional sense. The body camera transcript as characterized in ECF 57 depicts officers stopping a different SUV, then noticing Wilson already parked vehicle. The advanced point is not that the officer loses all authority the instant a driver parks or exits. Police may act on reasonable suspicion or probable cause based on conduct observed moments earlier. But the material issue is whether the FNR imported categorical traffic stop principles without accurately identifying when Wilson was seized, what officers had observed, and what legal authority existed at that moment. The question should therefore be decomposed. Did officers observe Wilson operate the vehicle without plates before he parked? And did they even notice it? They say they did, but they really didn't, right? They didn't notice me. They noticed the speeding. And then after the fact, once they got out, then they saw the plates and they said, oh, well, he don't have plates, which shows exactly that I was not on their radar, nor were they paying attention to me at first. But they're trying to say after the fact, through post hoc justification and ratification, that they always were watching for me, right? If that was the case, they would have run around the person that was sitting at the stop sign for 15 seconds to pursue me, but they did not. And then the clear statement of, oh, and he don't have plates, call him back. 2, if yes, what Oregon law did that observation objectively implicate? 3, did a seizure begin when officers called Wilson back, when commands were issued, when physical control was exercised, or at handcuffing? 4, what facts were known at each moment? 5, what degree of intrusion was justified at each stage? Because there was a consensual contact, which was stated under deposition that I could have walked off if I wanted to, but that's not being brought in. Investigative detention, handcuffing, or arrest. The traffic stop label can obscure these temporal labors. Appellate advocacy should force them apart. Now, the core issue 3, movement, flight, resistant, and the reason for escalation. The FNR reportedly described Wilson as attempting to walk away. Clearly not. Plaintiff's record theory is that he turned towards Officer Junt to request the name and badge number, and that Junt acknowledged the conduct was non-threatening. This dispute matters because flight or active resistance or passive resistance and verbal challenge have different doctrinal consequences. That's a material fact that has been challenged. I don't see how this is disputed. I don't see how that this didn't even survive in and of itself. Under Graham versus Connor, active resistance and attempted flight weigh in the government's favor in the excess of force balance. But under the Ninth Circuit's cases such as Blackenhorn versus City of Orange and Rice versus Morehouse, okay, which is what we're about to study right now, force against a person whom a jury could find to be non-threatening and merely passive resistance may present a tribal constitution question. So I want to see if this is actually, yeah, let's actually do it over here real quick. All right. Boom. Okay. Now let's check out the Rice versus Morehouse. This is pretty identical to mine, all right? Pretty identical. Happened back in 2021. And we're going to zoom in here just a little bit. Whoa, not too much. Okay. So the opinion summary is that the Ninth Circuit reversed the district court's grant of summary judgment for police officers on the basis of qualified immunity in an action brought by plaintiff under 42 U.S.C. 1983, alleging violation of his constitutional rights, including his Fourth Amendment right to be free from unreasonable seizures. Okay, we hear that? The Ninth Circuit reversed the district court's grant of summary judgment. Why? Let's get into it. In this case, the officers tripped plaintiff so that he fell to the ground, pinned him down, and handcuffed him. Plaintiff fell on his face, sustained long-term physical injuries, and sustained emotional distress as a result of the encounter. The panel rejected the officer's contention that the notice of appeal failed to comply with the Federal Rule of Appellate Procedure 3C. The panel also concluded that although there are material facts in dispute, when the facts are taken in light most favorable to the plaintiff, a reasonable jury could find that the plaintiff engaged in passive resistance and that the officer's takedown, or let's say in my situation, the arrest of plaintiff, involved unconstitutionally excessive force. Furthermore, because the right to be free from the application of non-trivial force for engaging in mere passive resistance was clearly established at the time, the officers are not entitled to qualified immunity. Accordingly, the panel remanded for further proceedings. Almost identical. Almost identical. Again, Civil Rights Panel reversed the district court summary judgment in favor of the police officers on the basis of qualified immunity and remanded in an action brought pursuant to 42, alleging that the defendants used excessive force when they executed a takedown maneuver while holding plaintiff in a police lead position. That is, they tripped plaintiff so that he would fall to the ground, right? Because the plaintiff did not specifically indicate that he was appealing from the district court summary judgment order and granting defendant's motion summary for judgment on the takedown, the panel concluded that the plaintiff provided sufficient notice to the defendants of the intended scope of his appeal, and defendants did not suffer prejudice. They had an opportunity to, and actually did, fully brief the issue. Viewing the facts in light most favorable to the plaintiff, as was required, the panel concluded that a reasonable jury could find that the plaintiff engaged in passive resistance and that the defendant's takedown, or in my situation, takedown, the plaintiff involved unconstitutionally excessive force, or in this situation, a Fourth Amendment violation that they arrested me without probable cause. Furthermore, because the right to be free from the application of non-trivial force for engaging in mere passive resistance, right, me asking for their badge numbers and not necessarily complying because it was a consensual encounter, was clearly established before December 2011. Defendants were not immune from suit. A reversal. Straight up reversal, bro. So when it comes down to it, everybody being like, okay, right, they didn't view the facts in light most favorable to me, as was required. They did not. Not even, and mislabeled things in relation to them actually being a traffic stop when it was not. Officers in deposition even said in and of itself that, yeah, no, this wasn't a traffic stop. You could have actually walked away at any time. It was a consensual encounter. All right. So let's see what we have here. We already did the knees. Nope, we haven't done the knees. We was on Morehouse. Okay. Now, but Zorn versus Linton now supplies an important caution. Even where a jury could find excessive force under the Fourth Amendment, qualified immunity requires clearly established law defined at a high degree for factual specificity. Zorn reversed a court of appeals that relied on a generalized passive resistance principle without sufficiently analogous precedent concerning a warned wrist lock used to move a resistant protester. Thus, the force claim needs two separate demonstrations. One, a constitutional violation under the plaintiff's favorable facts. The degree of force was objectively unreasonable under the totality of the circumstances. Two, clearly established law. A pre-existing Supreme Court or Ninth Circuit case, or an obvious case principle of sufficient specificity, would have put every reasonable officer on notice that the particular force under materially similar circumstances was unlawful. The first does not automatically prove the second. Core Issue 4, protected speech, temporal sequence, and retaliatory arrest. Plaintiff's recorded theory is that he verbally challenged police authority, requested identifying information, and was handcuffed within seconds. The objection cited admissions that asking for badge numbers did not itself constitute an obstruction and characterized Wilson as cordial and non-threatening. The First Amendment claim cannot be analyzed solely through temporal proximity. Because Neves versus Barlett generally requires a retaliatory arrest plaintiff to plead and prove absence of probable cause. Neves recognized a narrow exemption where objective evidence shows that similarly situated people not engaged in protected speech ordinarily would have not been arrested. Gonzalez versus Trevino clarified that the exemption does not demand virtually identical named compatriots. Objective evidence about non-enforcement patterns can suffice. In the Ninth Circuit, Ballantyne versus Tucker in 2022 is useful because the court permitted a retaliatory arrest theory to proceed under the Neves framework where the recorded evidence supported differential enforcement. But the lesson is not that close timing equals retaliation. The lesson is to build the evidentiary chain. Protected speech, officer awareness, adverse action, causation, absence of probable cause or Neves exemption, and clearly established laws. If objective probable cause existed independently, the retaliation claim becomes substantially more difficult unless the Neves-Gonzalez exception is supported with objective evidence. Now, the good, the bad, and the ugly in Candor First Litigation Audit. The objections survived the procedural attack. Nelson granted excess page relief and denied the motion to strike. This leaves a detailed preservation record rather than an appellate record in which objections vanish on a technicality. The district judge herself cataloged the objections. The final order expressly recognized 6 alleged contradictions, 14 asserted material disputes, and 19 objections. That makes it difficult to characterize the post-judgment Rule 56 issue as wholly new. The strongest theory is conventional, not exotic. Because Tolan, Anderson, Scott, Devenpeck, Beck, Graham, Neves, and Pearson are mainstream controlling authorities. The appeal is strongest when it speaks that language. The objective evidence exists. Deposition testimony and body camera evidence are much more powerful than naked allegations. Such cases as Tolan, Newmaker, Blakenhorn, Rice, and Rosenbaum demonstrate the appellate significance of objective or testimonial evidence that leaves material historical facts genuinely disputed. Summary judgment itself receives de novo review on appeal. The Ninth Circuit does not defer to Nelson's ultimate Rule 56 conclusion. It independently applies the summary judgment standard to the record. The perfected Rule 59E theory has become narrower and stronger. It now expressly recognizes Devenpeck, frames the Venn issue as a jury permissive inference rather than a conclusory established fact, treats the traffic stop issue as an inception scope question rather than a magic label, and relegates ADR to alternative relief. And then the case has a coherent appellate theme. A single theme can organize multiple claims. The court could not convert contested historical predicates into established facts against the non-movement and then use those predicates to decide constitutional liability and qualified immunity. Now, the bad, the defendants and the judgment have going for them. Nelson expressly stated that de novo review occurred. An appeal premised only on the brevity of the order or an inference that she did not read the objections is unlikely to carry the day. The appellate brief must identify substantive error, right? The Ninth Circuit may affirm on any ground supported by the record. Even if the district court stated rationale is flawed, the panel may affirm if an alternative legal basis is supported. The appellate, therefore, must anticipate every objectively available probable cause ground and every independent qualified immunity ground. The wrong announced offense does not decide probable cause. Devenpeck is a serious defense side authority. The statement obstruction of justice is evidence, but not a dispositive Fourth Amendment rule. Objective facts known at the moment of seizure control. Video evidence can cut both ways. If body camera footage blatantly contradicts plaintiff's account, Scott permits the court to reject that account as summary judgment, but it doesn't. The appellate preservation must be video precise rather than rhetorical. Qualified immunity is now especially demanding. Zorn reinforces that clearly established law ordinarily requires materially analogous precedent, particularly in fact-sensitive force cases. A generalized statement such as officers cannot use unreasonable force is insufficient. The First Amendment claim has probable cause barrier. Under Neves, objective probable cause generally defeats a retaliatory arrest claim unless the narrow exemption is supported by objective evidence. Now, some disputes may be semantic rather than outcome determinative, and whether the encounter is called a traffic stop, whether the command was described as a request, or whether no citation ultimately issued matters only if connected to a legal element. And then the ugly, the issues that should not lead the appeal. The fruit of the poisonous tree, the Miranda as proof of arrest, which I do think it should, but they're saying it shouldn't. Miranda as proof of arrest. The fact that officers administered Miranda warnings may be circumstantial context, but it does not conclusively prove the constitutional moment of arrest. Officers can give warnings prophylactically. Moreover, Vega versus Taco in 2022 holds that Miranda violation is not itself a basis for 1983 damages. Miranda should be therefore peripheral and not structural. And then the ADR as structural due process requiring reversal, which I still think it should be again because there was a rule there that was ruled, but not as a lead anyways, more of a pillar. Begins with unless otherwise directed by the court, provides that unless otherwise ordered, there is no state pending, ADR ECF 69. But she never directed that they don't have to do it as well. So that's why I want to utilize it. This makes the theory that summary judgment was legally impossible before ADR substantially weaker than Rule 56 theory. ADR remains useful as a case management and prejudice argument, but not as the centerpiece of the constitutional reversal. And then the Hensley abolished qualified immunity theory involved, of course, the preemption and governmental contractor defense, where the federal government neither ordered nor authorized the challenged conduct. It did not overrule, of course, Harlow, Pearson, and other qualified immunity line. Indeed, the Supreme Court decided Zorn 1 month earlier and applied qualified immunity forcefully. The historical argument may be preserved for the higher court reconsideration, but a district judge and Ninth Circuit panel remained bound by existing Supreme Court doctrine. The Monell based on 3 officers in 1 incident is kind of the ugly and not a lead on. The equal protection, I was treated differently from the speeding driver, which honestly I think is a very big deal because they just let them go while they speeded while they're over here messing with me on an administrative side. And then the judicial motive as far as public speeches and her perceived hypocrisy. Whatever one thinks of the judge's public statements about accountability, which this is why, y'all said, well, are you going to include it into, it's not necessarily a leading one. But personalizing the appeal, it most definitely reduces doctrinal force and invites the panel to treat a serious Rule 56 argument as dissatisfaction with an adverse judgment rather than the actual facts in and of themselves of the mistakes that were made as far as the rulings moving in favor of them rather than the non-moving party, right? You have to look at it in that way. So, of course, I have an audit and everything like that. This goes really, really deep. It's like literally 56 pages of the depths of things, as y'all can tell. And it really, 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 really breaks it down to understand, the Morehouse prong and the reversal there and how I feel as though, or the Rice versus Morehouse, and how I feel really strong about the appeal in and of itself, as far as a ruling is concerned, to work on behalf of me, because there just are so many mistakes as far as them not moving in favor of me and looking in favor of me. She don't have to give me a paragraph by paragraph or a really deep brief in relation. It's not that rule in and of itself, but they did move not in favor of me. There's exclusions of actual facts and judgments as though this was a traffic stop when it was not. They literally, how do you label it a traffic stop upon me when you have someone else literally in custody as far as the traffic stop is concerned, and then an officer in the deposition stating that, it wasn't a traffic stop, it was a consensual encounter, you could have walked away at any time. How is that literally overlooked altogether? I'm not sure. But that's literally where we're standing at this point right now. And what I think is interesting, no matter what, is that I'm going on these deeper principles. First off, to create the errors or to bring up the errors that was brought forth, but then also the deeper principles in Hensley, which only the higher courts, I guess, apparently are really looking at. I tried to bring it forth in this lower court as far as the first level of the federal, the district federal court, to try and see where we could get as far as those arguments are concerned. But apparently there's not. They're just blanketly utilizing still the qualified immunity, and they're utilizing Zorn in relation to that.
Can you leverage in the leaving the traffic stop for which was a safety thing to pursue a non-safety issue, and for officer safety and that whole genre of safety issues, abandoning a safety issue to pursue this bogus thing that you're involved in?
Well, I mean, as far as arguments wise, it's more based on, it would be more based on not necessarily, see, because those arguments were already presented, like I already presented those arguments very heavily, and they weren't necessarily given full credit as they should have been. It was,
I'm saying that they opened the door by their actions of leaving that the big quotes around safety, pulling over the safety and leaving that quote safety issue to pursue this non-safety issue. So,
well, the thing is that the judge, especially the magistrate judge, in this situation, literally moved in favor of them and their post hoc rationalization, right? So, of course, all of these officers and all of these defense lawyers, what they're going to do is they're going to try and say, how can we make it seem as though you already knew that, Cameron didn't have plates, right? Well, we're just going to state it that he didn't have plates and we observed him not having plates, right? Which is so far from the truth.
We're kicking over giants, and we're going to kick over qualified immunity, and on our way, let's kick over officer safety issue.
Well, I think the biggest thing here that's going to be definitely observed for the appeal in the Ninth Circuit is that the judge moved in favor of their version of story that literally contradicts my version of the story and the actual facts. Officer Delancey literally got out the car, right? First off, I pass, they pass. They don't notice that my plate has private traveler plates because it's on the back. It wasn't on the front. It was only on the back. So they turn around because they're pulling over the person that's speeding, doing 40 miles an hour in a 25, okay? So they speed up, and they get up and do the same safety risk, and then they pull up and get behind. I turn, and I park. 15 seconds at least elapses from when I turn to when the actual person that's getting pulled over actually turns. So there's a full 15 seconds right there. If they were worried about me, they would have went around the person and come to get me. Secondary is that they didn't jump out the car and nor were they talking to say, hey, I want you to go get that other guy that didn't have plates on his vehicle. Go and immediately get him. Officer Delancey got out of the car and made a statement that was on the camera. Oh, and he don't have plates on his vehicle. Call him back. Meaning and showing that right there at that moment did they notice that I didn't have plates on my vehicle. But I wasn't in charge of the vehicle. I wasn't in charge, nor was I in operation of the vehicle. And this is a very strong argument here, because what's happening is that although they saw that my plate didn't have vehicles, they didn't truly, and they could say, okay, well, yeah, we observed him in the body cam footage, but at said time and place, they didn't know. At said time and place, they didn't know that I wasn't. It was after the fact that they got out the car, right? So I was not in operation and I was not in charge of the vehicle. These facts right here are being heavily argued in my WSP case. Now, yes, you can make, somewhat of a stop if you observed one driving, right? If you actually seen movement of the car in and of itself, right? Cool. That's good. There's no problem there. And they could say that, yeah, they saw me drive the vehicle. But then again, they didn't notice the plates until after they got out of the vehicle and after I was out of the vehicle whatsoever. Then you have Ryan coming up to me and him saying, him talking to me, and yeah, we saw you driving, so we could actually, we have a reason to talk to you. That's cool. But then in deposition, he stated that it was a consensual encounter and that I could have walked away at any point in time. Right? So these confessions and admissions are very huge because it shows that it wasn't a traffic stop, but yet the judge is sitting here saying that it was a traffic stop. It wasn't, right? And that was based on officer testimony. So with the judge acquiescing to disputes, they're labeling it a traffic stop. I'm saying it wasn't a traffic stop, just like we're doing over in WSP right now, right? Which is, it was a traffic stop. And I'm over here labeling it as a community caretaking stop, which they also said it was a community caretaking stop. And then them admitting, in the Washington State Patrol one that, well, you can't cite him any tickets because you never actually saw him drive or move the vehicle whatsoever. So if you can't cite me, you can't ask me for my ID either, right? So I think it's the we're going to take what they said is truth versus a disputed fact, what Cameron states is his stated truth, and we're just going to acquiesce to that. When in all actuality, they're supposed to look at it in favor of the non-moving party. Well, Cameron's saying that it wasn't, and this actually could be a disputed fact that the jury has to actually decide. I can't make that decision at this point. If the jury sees that it possibly wasn't a traffic stop, then that's how they view it, but I can't make that decision at this point. These are disputed facts, right? And they didn't do that. They literally said, we're going to make these disputed facts our facts, and we're going to acquiesce to their facts, and we're just going to dismiss it outright. And they didn't do that. Yes, this document is also on Discord as well, I believe. Yeah, it is. It's right there in the Wise Domian chat, but let me see. I'll throw it over. Nope, it's in the general chat as well. The anatomy of the federal summary. And so, it's definitely very important to kind of just like understand, first off, your position's cool, right? But you also have to understand what they're going to argue too, and what they're going to bring forth. And once you understand both sides, you can look at it and say, okay, I'm going to bring these topics up. But yeah, I mean, I feel like for sure that they, and this is not just because I want to say, oh, it's adverse to what I want to happen. It's not just that. It's that these rules are put in place for a certain reason. And with what the FNR states that all officers, she's giving what she states as far as all officers gave their badge numbers. That's a lie. They didn't. That's going directly against the factual record as far as the video camera is concerned. I turned. I didn't try and leave. She's labeling as though I tried to flight or was in flight in some form or fashion. I turned and asked the dude for his name. He never gave it. I got arrested. Right? That was an arrest. Miranda rights were read. I was arrested for obstruction of justice. The obstruction of justice was never even said. And the reason for that is because that's very destructive of the actual case in and of itself. If dude had reasonable articulable suspicion of probable cause for the VIN, then why did he arrest me for obstruction of justice? Why didn't he arrest me for that point saying, well, you covered up your VIN? Even though the covering of the VIN is actually secondary, right? Just like failure to ID would be secondary in relation to a crime in and of itself. So these are the things that I actually have to bring up because, again, apparently, because even the federal judge is sitting here acquiescing to what the FNR on the magistrate judge said when she clearly made errors. Like, she lied. She put in factual truths that are essentially lies. It's not the truth. All officers did not identify. This was not a traffic stop in any sense of the form in and of itself. They didn't mention anything in relation to the VIN until after we got back down to my car, right? I was arrested for obstruction of justice, which I had not have done obstruction of justice. What do you mean? Where was the probable cause? There was no probable cause to be arrested. They didn't even... if anything, you could have been like, okay, well, you're failing to ID. But they couldn't even do a failure to ID because they never asked me for my ID. They gave me a command that was unlawful to go back down to my vehicle to give them information that they requested when they didn't pull me over. So there are a lot of and like I said, the Rice versus Morehouse, um, he essentially did is that he was pretty much in his car. They said they pulled him over for some reason. He denied that reason and was like, "Bro, no, I didn't do that. Like, let y'all get a sergeant out here." They pulled him up out the car, right, and tripped him and put him down to the ground and hurt him, right. And all he did was ask. It was passive resistance. He said, "No, I'm not giving up my ID. I'm asking for a sergeant." So passive resistance, right? We're speaking here, and yeah, they arrested him, right? But he took a federal civil lawsuit. They gave summary judgment. He took it up to the Ninth Circuit and said, "Listen, man, this is passive resistance. I don't see how y'all gonna give summary judgment for me just giving passive resistance. I asked for a sergeant," and they reversed it right back down to have it move forward to jury trial. Now, what's important about that is his case is literally identical to everybody who's had their window broken or gotten pulled out the car, which essentially shows that just because you ask for a supervisor and you have passive resistance, again, this is, let me see if I'll look it up one more time, find, so I can paste it, or no, I have it already searched over here. So, or I thought I did. Let's do a reopen of closed tab. Then we'll do a back. Let me search copy. Anybody who's gone through a situation where they've gotten pulled out the car, that case right there is going to help you in every regard. Because he brought forth the lawsuit, okay? They found summary judgment on his ass in the Ninth Circuit. They granted that summary judgment. He took it up to the Ninth Circuit of Appeals, and they reversed it and said, "Nope, y'all proceed down, go out to trial," right? Because passive resistance doesn't allow officers to do what they did. Passive resistance, meaning that me asking for a sergeant or me denying to give my ID at said point in time, does not still give the eligibility of the cops to do what they be doing, especially asking a person about the car or beating somebody up when there's no even post safety risk whatsoever. And that's why I say we got to get to the depths of it. That's why I put on my, on the post in relation to speaking about Rice and Morehouse on Facebook, I posted or I tagged Dan, because Dan gets really nervous about this. He's like, "I got my window busted out and I should have just," it's like, bro, no, you're asking questions. That is passive resistance. And they even told homie to stay in the car. They said, "Sit tight, we'll be right back." And then when the sergeant came back, he literally just busted his window within 15 seconds. So, and the door was unlocked. They could have just opened the door if they wanted to. I mean, that would have been illegal, but they still could have done it. So, I go into a lot more deeper comprehension as far as what I'm going to be bringing forth in the Ninth Circuit, and of course the Rule 59E motion, and the strategic way that I'm going to bring that forth to try and pull out her to actually maybe correct some of the decisions that she made in relation to this. But it's far from over, bro. I got a motion that I'm bringing forth to have her amend or alter her judgment based on the mistakes that I'm going to invoke and bring forth to her, and the clear errors that she probably apparently just overlooked, maybe. She could have possibly just overlooked it, and that could be something. Maybe she was just scanning through and doing speed reading, and that's cool. I'm not tripping on it, but I got to call out the mistake so that you can give an answer back, so that way when I do appeal, right, that we have a clear understanding that you possibly missed these errors that you made. And I would like to see if you can alter or amend that. It's not an attack against her. I'm not, you're a bad judge or anything. That's got nothing, that's not what's going on here. It's that there are serious mistakes that need to be addressed, and hopefully you address them properly rather than just ignoring them outright. And if you choose to do so, we will take it to the appeal court and get a reversal, because Rice versus Morehouse is essentially identical to my situation in a sense, as far as a reversal is concerned. Passive aggressive, me asking questions, badge numbers, does not give justification for them to do that, especially where there's not probable cause of a true actual crime being committed, because everybody knows that you can cover up the VIN all you want. You can't tell me I can't cover up my VIN. If I want to remain private as far as my VIN being covered up, you cannot utilize the covering of the VIN. It's a secondary type charge. You've covered up the VIN to conceal a crime that you either committed, or that you have a stolen vehicle, or that it's altered and it has, stolen parts on it or something like that. It's like secondary, like you committed a crime and then you also covered that VIN to conceal that you had committed a crime or that the car is stolen or something like that. It's secondary. It's not an additional, "Oh, you covered the VIN, so that's crime." No, that's not how this goes. And And that in and of itself, covering of the VIN does not establish probable cause of a crime being committed whatsoever, or that it was a stolen vehicle. That's not probable cause or even reasonable suspicion. Having the VIN cover is not reasonable suspicion that the car could be stolen, right? So they've made a lot of mistakes here, and we just got to take it up. And I'm kind of excited that I get to take it up and move forward in relation to getting the higher courts to look at the principles, but then also utilizing the Hensley versus Floor to possibly get qualified immunity overturned in relation to that as well, at least on that realm or on that side of things. And so, yeah, wanted to go through that today with y'all, break that down, show y'all what we're going through, and then how we're combating it still to this day. Like, we ain't lost. It's dismissed, but we ain't lost. We ain't done. How many things go up to the appellate courts and get reversed or the circuit courts and get reversed all the time? Almost all the time. Every month, every week, things are just getting reversed. And so I'm pretty excited to take it up to the higher courts to have them reverse it if they have to. Because I know there's errors. There's clear errors. There's lies in the FNR or the factual findings. They moved in relation to the movements rather than looking at things in favor of me and seeing the truth. I mean, they didn't even mention the truth. They had to lie. They excluded the obstruction. They said all officers identified. They said it was a traffic stop. Those are lies. They're not the truth. And so, yeah, that's where we're at. What y'all got? What y'all got? Oh, nobody's speaking today. All right. All right.
I think it's fun to be a champion.
Hey, bro.
I'm a bit lost, Cameron. That was wild, bro. I mean, 555 pages? Is that what you said? Wow.
No, the anatomy of the federal summary judgment and breaking everything down as far as Rule 56E and then the procedural steps as far as moving forward with the appeal is only 54 pages. But it does break down, everything as far as the scenarios are concerned, right? My first scenario is possibly that the Rule 56.9E is granted in whole. I have a scenario B, 56.9E granted in part. Of course, it could be denied with a detailed order. It could be denied similarly. And then scenario E is a partial Ninth Circuit reversal, which I really do think that's a big deal. I mean, I really do think there's a strong possibility of having someone else subjectively look at it that doesn't have ties directly to Mount Hood, right? Which this judge does. She literally did a TED talk out there, right? I mean, there's probably some deeper implications there that I'm not going to address, of course, in the Rule 56E or the 56E motion or even in the appeal. It's just going to be on the facts. There's lies on the factual record. It was not a traffic stop. Not all of the officers stated their names like was stated from the magistrate. That's not true. This was a post hoc rationalization as far as the VIN is concerned. They never mentioned the VIN until after I got arrested. All of these things heavily are in my favor, and they're supposed to be viewed in light of me, and they were not. And since they weren't, the circuit's going to have to reverse it, because at this stage in the proceedings, they are not supposed to rule in relation to any kind of facts in any sort to say we're going to agree with this one even though it's disputed, when we're actually supposed to actually move in favor of Cameron when he's disputing it. It's a trip. It's like y'all are violating your own rules, and we clearly see that it's happening with me, and that's okay. I mean, first off, you got to understand that this was probably one of the best videos and situations online to prove that these cops know about the right to travel. That's number one. Number two is I got an opportunity now to go to the Ninth Circuit and have it reversed, right? And that's a big deal to me. First off, I get the experience, right? All of this is experience for me, okay? You have spent a lot of money on this, there's no doubt, right? But it's still the experience of being able to figure out, okay, well, what's going to go wrong and how is it go wrong and how do I make sure to correct myself and what mistakes shall I not make? What mistakes do I keep myself away from now on? And then how can I be better in everything that I'm doing, which is why I'm bringing this all to y'all. I want to make sure that y'all are the best of the best as far as seeing what possible things could happen to you and then how to properly combat those to where you don't have to go through the same things that I'm going through. But at the same time, you may have to go through something like this. And you need to understand that once a case has been dismissed, that's not the end. You have the rule 59 or 56E, and of course you just have to, appeal that bad boy. Never lose hope, never lose sight, don't give in, stand strong, and hold steady.
I think, Cam, there's an important point to make right here in that if you were to appeal the case as it is, the appeals court would address the findings and recommendations of the magistrate, right?
Yep.
So if you don't file the Rule 59,
Yeah.
then you're not rebutting the presumptions of the magistrate. And
Correct.
so this is an essential part of the process where you go back and you actually correct the record upon appeal, saying, hey, these facts have been misconstrued, they've been mischaracterized, they're factually false, they're omitted, so you have to make that distinction and exception before going to appeals. Otherwise, the appeals court's going to say, well, these are the findings, these are the factual findings, and so we're going to go off that.
Yep. And something that's kind of important on this too is it kind of relates right back over to Hayden and his situation in Florida. Hayden, did his notice and demand to dismiss as unconstitutionally applied with some language within that was on a suppression type vibe. And the judge literally said, okay, well, we're going to take this as a motion to suppress, and we're going to set an evidentiary hearing. They set the evidentiary hearing. They go through the evidentiary hearing. Cool. Everything's good. They have all the discussion. Judge comes out and gives an order with factual findings and conclusions of law, right? So we get that back, and yeah, she granted the suppression, mostly, but then said in other aspects we're going to deny the suppression for his other alternative relief that he was asking for. But what we noticed is when we're looking at the actual order in and of itself, even that judge made mistakes. So what did Hayden do? Instead of just allowing the motion to suppress to just stay as it was, he came back with a recommendation, or not a recommendation, a reconsideration, and brought forth the errors that the court made in its findings. She made findings with certain cases, right? What Hayden do? Hayden came back again after, even though the order, he was granted his motion to suppress the fruit of the poisonous tree. He was granted it, but the court still made errors in its order. So he came back and said, I want you to reconsider it in full again because you made errors in relation to your findings, actually. Once he put that in, nolo prosecute. Came right from the DA. Nolo prosecute, all three charges, get it out of here. We're done, right? So that's a really good point, Sean, is that and I mean, dude, even with us even with, Hayden getting the decision of, yeah, I'm going to suppress everything, right? The court still made errors, and he still came through to clarify on the record that, no, you still, even though you gave me what I'm asking for, you still made errors. And I'm going to call you out for it and put it on the record, right? So, yeah, you got to rebut that shit, bro. At all. Don't just sit there and accept it. You got to rebut it. So.
Yeah, I think this is just an important distinction for our group, and I love that you're doing this video, Cam, because these courts are gonna try to shut us down. These magistrates, especially, are going to try to shut us down over and over, and they're gonna obfuscate, they're gonna omit, they're going to make up shit that never happened, like is going on in your case, and unless we rebut all those presumptive facts, I love the post hoc ergo hoc. It's just like, they're making all these assumptions based on causation that never happened, or speculation, or the other side story that doesn't align with the actual facts. This is imperative that we rebut these presumptions and use the process prior to going to the appeals court, because as we know, less than 2% of appeals win. So unless you establish facts on the record, then you're probably going to get shut down on the appeals, and then you're going to have to go for post-judgment relief at the Supreme Court level, rather.
Yep. And whether that happens or not, I'm still excited for it no matter what, because, it's very clear what happened to me, bro. And to say that they can just do whatever they want like they did, and then, utilize that post hoc justification or ratification later, which is just essentially lies. We're going to make up a story that we knew all of this after the fact. You didn't, you're just making it up later to make yourself look and seem as though you did beforehand. And of course, that's what they're going to do. The defense is going to utilize it in that form and fashion, but we've Definitely with Hood River, no matter what, this has been the greatest experience. I can only take it as the greatest experience, and I'm continuing. I mean, it's not over with, but it's been so great because first off, Griffin doesn't work over at Hood River no more. He's gone. You know, he saw the issues with Hood River. I mean, literally, Griffin wasn't even truly a police officer at the time that he came up and addressed me. Anyways, he hadn't even gone through the police academy, right? So there's a lot of issues here that are still haven't been brought forth that I think will later be brought forth if we can get it all the way to jury trial. But regardless of it, no matter what, regardless of what happens all the way out to the end, we're still where we're at right now. And I find it a blessing to literally have to go through these things. I'm not mad. Like I said, I ain't mad at all. I look at it as cool, another opportunity to go through another situation that I haven't gone through before, to constantly learn and to be able to distill the information as far as my experience is concerned to somebody else who may possibly also go through the other experience as well. And so it's a blessing in every form and fashion. Go ahead, Zach.
You think they're going to let you end it with before it gets all the way to ending qualified immunity by just ending your case?
I think listen, there's so many scenarios and possible, things that could happen. I think honestly, like Sam was saying, he thinks that the federal judge is gonna stay on her stance. He doesn't think that she'll change everything. And then I'll have to go to the Ninth Circuit to get some possible change, and see if we get it remanded and sent back down. He's saying if I bring up everything fairly good enough in the appellate brief, asking the right questions and bringing up, the issues like we've spoken of today, but in more detail and with more advanced legalese, that it has a really strong chance of getting reversed. But if not, yeah, we take it all the way up. And I'm not tripping on taking it all the way up, because that is where we'll actually get the arguments as far as Hensley versus Floor to be established. And where we can really start looking at, hey, truly, y'all are giving qualified immunity all over the place, but y'all are conflicting, right? And see if I can, be the first one to get it up there to argue that in relation to qualified immunity. And that, in and of itself, this whole thing, as far as how the universe is allowing this to play out, may just allow me to be that person to go up to the Supreme Court to argue this finally out, the Hensley versus Floor and the parallel principles articulated therein, to really bring an end to qualified immunity. And that's why I say I'm not upset in any form or fashion, because if I have to go all the way up to do it, hey man, who better to do such than me, right? Y'all bring it forth and show me, and then we'll go through that. But I don't know. I'm sorry. Here you go. I'm still working. I mean, Operation Wise Dumb. All right, Zach, what you got, brother?
So, quick question on the post hoc justification. Kind of like in my case, how it was simply the unsafe lane change and then a failure to ID, which was her reasoning for opening my car door. The justification of alleged observable signs of DUI was not mentioned until after the sergeant had got there, and she only mentioned it to him when he asked, versus in her report, she says that she observed them as soon as we made contact. And so outlining my 1983, I just kind of wanted to be ahead of that. I was looking at in point 5 under the core issue, the pre-seizure, and the objective offense area says under Devin Prick versus Alford, basically that the arrest doesn't become unconstitutional merely because the officer announced the wrong offense or subjectively relied on an inapt label. If objective probable cause existed for some offense based on facts known at the time, the arrest may be valid. So again, she's purporting to have observed these DUI indicators, but in the timeline of the transcript and the video, it shows that that was never mentioned or never made clear. She never questioned about DUI indicators, any of that. So, but there was an actual unsafe lane change that was observed. There was the reason for, that was the alleged reason for the traffic stop. And then again, the identification, even though it wasn't a crime, traffic infraction that she needs to cite. And so if that's her alleged reason for, validating the stop in and of itself and the demand for ID or request for it, could she still try to come back around and bring up the DUI indicators? I'm just, again, trying to think ahead for the arguments in federal court.
Well, I mean, when you look at it though, is we have really good judges out there, federal judges out there. There's no doubt about it, right? We had Thomas E. Johnson last year, which is one of the ones that I always staple myself on in relation to unconstitutionally extending a stop beyond a de minimis amount of time, right? Is a violation, Fourth Amendment. Then, you got a valid Terry stop, but asking someone to get out of the car without, you posing a safety risk to the officers is null in and of itself, right? And void. So, I mean, that's kind of where you're sitting at. You're sitting at the situation where, even though you look at it kind of in an objective standpoint of saying, okay, we're going to look at it from the defense side, which is more important, the constitutional violations, right, or the actual statutory claims that they're going to be trying to utilize as far as the process and procedure is concerned. And always at the forefront is the constitutional violations, because no one can utilize a wrong to bring forth a claim against you. It's like a legal maxim that's been around forever. I forget exactly how it's titled, but no one can utilize a wrong in an action that's brought forth against you. You can't, if you want to bring forth an action against me, you have to be right in everything that you did. You can't do a wrong to then justify your claim in the first place. And that's the core principle as far as your 1983 claim that you're going to bring forth. And then also, it also depends upon the attorneys that's bringing it forth. Like, check it. I'm going against a private law firm right now in Hood River, and I've lost. They've literally acquiesced to all of their facts as though it's true. And then I'm going against the attorney general side on the other side. You see what I'm saying? And a team of them. I mean, I'm going against two different teams, there's no doubt. But when it comes to yours, you had a passenger, right? Who's to say that passenger hadn't had the alcohol smell on him versus you? And then what was the mission of the stop in and of itself, right? It's not like she it's not like she said that there was reckless driving. That was never brought forth. Maybe it was an improper lane change, unsafe. That's up for argument if it was unsafe or not. Maybe it was improper, right? But at that point, that would have been the only thing that you could have cited me for. And again, passive resistance, literally the passive resistance of asking for a sergeant and not giving up the ID was definitely what was going on in the Moore case. And if I haven't pasted it, I'll paste it again. Let me see. He there it goes. All you got to do is search that one up. He brought forth the argument, essentially almost exactly what you went through, in a sense. And he asked for a supervisor. They pulled him up out the car, handed him up, you know what I'm saying? And damaged him some, because they threw him, down and damaged his face. He brought forth the lawsuit because it was excessive. There was no need for it, right? Just like it was excessive for them to even open up your car door when you're clearly requesting a supervisor because you're doing passive resistance. You're rebutting what they're bringing forth. That's why I say, I know that we always look at it from the standpoint of people that like to argue us and put us down in relation to how they see the law is concerned. But there's literally a procedure. Now, yes, you don't always have to get a supervisor and all that kind of cool stuff. I get that. There's case law on that as well. But at the same time, passive resistance is not a complete refusal to cooperate in every form or fashion. It's not. You're just asking questions and you're trying to get clarifications in relation to the justification in which they're bringing forth when you know that it's not true. And that's where the argument starts. And you got to remember that we always got arguments, regardless of what's already been decided before. It can be changed. It can be overturned. It can be overruled. There's new precedent all the time that's getting things changed on the back end. So why not be that proponent of being able to argue it to make the changes rather than not?
Exactly.
Right? Because clearly established law can be changed, even in itself, in some form or fashion. It just directly pertains to your exact situation rather than somebody else's. And so if your situation is changed by any, or is a little bit different in any form or fashion, try and utilize it, bring it in, try and set precedent. And that's why, that's why I'm doing what I'm doing, because I'm trying to set precedent, bro. I'm trying to make changes. So
Keep going.
yeah.
All right, thank you much. Appreciate it.
Yeah, for sure. Yeah, it's pretty exciting, bro. In relation to everything, Jack, what you got?
Me, I don't got too much right now.
Where are you at in yours? You already did your 56E or what?
Oh, okay. So, with the Ohio, yeah, well, I'm suing the judge and prosecutor. They just want to apply immunity right away. And so I did the 59E, and I'm like giving them explanations as to like why they shouldn't be just automatically applying immunity. Of course, they just stuck with the main argument, saying like my shit's baseless, and filed a appeal in the Sixth Circuit Court. And right now, I'm just trying to get on. I'm just waiting for them to get their asking gear and start saying something about my.
Did you ever get to do depositions on yours?
No, it hasn't even gone past screening. Yeah, so.
And what was the main core reasoning behind it?
Behind what? Behind the claim or?
The dismissal.
Immunity. They're like, okay, so under color of law, it's like, okay, they're doing actions that look lawful, but aren't, right? So I'm trying to say, hey, look, yes, I am saying things that make it sound like they're acting lawfully, but I'm saying they're not because they didn't follow judicial procedures and due process safeguards weren't adhered to. And I mean, like, literally, judicial rule number 1 is judges must follow the law. The law says I have to have a probable cause hearing within 48 hours. They did not do that. They're supposed to record these criminal cases via stenographer or audio and video, and they did not do that. And then the big one is they're supposed to make sure that when you plead guilty or take a plea deal, it's knowing, willing, and voluntary. For me, it was not. I even sent a freaking email to the judge in the trial court, though be it long, I kind of hit in the middle as to why I'm not making a willing, voluntary plea. And they're just kind of all ignoring that,
Yeah.
They don't want to just be like, oh, hey, look, these guys did fuck up. Let's try and fix it.
So how long ago was it when you turned in your appeal?
I was just looking at that about 5 minutes ago. And I forget. I think it's been about a month. Let's see. Hold on. Hold on. It's still up. I can look. May 21st. So over a month. Over 2 months.
Okay.
Yeah.
Still haven't gotten anything?
No. You want? I'll share screen if you want. How do I share screen? I forget. Share. There we go. Do you want me to share screen?
Oh, I was waiting for you. Yeah, yeah.
So this is what I don't like about the appeal court right now. I have no way of looking at number 9 or anything before that. So if I forgot what I have no idea. Like I scroll down, there's no extend anything. Now if I go up here, I see view full docket. It wants me to actually like pay for it and print it. It's all like printing stuff, which sucks. And I'm gonna hit run docket report. Oh, does it not? We'll see. I might have to spend money here. I don't know. Oh, it does let me see the full doc. Okay.
Yeah.
So yeah, filed. That's when I filed the notice. And they don't. So these guys are being a pain in the butt. So I used a tablet on to put my signature into the computer, and the computer tweaked it a little bit where it's a little bit more uniform looking, and it's really nice looking. So they don't want to say, oh, they want to say that's not my signature. Even this new stuff, like here, they put out a letter saying it's not signed. I'm like, it is signed. It's just the saved signature.
You
So
know you can do a slash s slash right before your name every time, and you ain't got to worry about doing a signature.
yeah, I'm gonna do that too. I'm gonna add both in.
Yeah.
I'm gonna have,
No,
and like I
I haven't
explained
done
to the
no
dude.
signatures, not one time in any of my federals. I just do just like this. Not one time if I ever signed
Nice.
anything.
So
Yeah.
what
Yeah,
is that?
That's your signature. That's like a digital signature. When you put the S, the slash S slash, that's like a digital signature, and you don't have to sign it.
and here's the crazy thing. Okay, so I think they're stalling a little bit because up at the beginning, I know I put in a motion for improperly and the paperwork, and then even down here back in July, they're like, "Oh, let's send him a letter saying he needs to pay or tell us why he can't pay." And it's
what?
like so I refiled the same shit, and
So
then
why?
I get a phone call a few days later, and they're like, "Oh, you don't need to file that again because we already have it." It's like, well, why just send me
Why
the
isn't
letter
it
saying?
docketed? Yeah.
Yeah, it no, it is docketed, you know. But yeah, it's kind of it's like they're not paying attention. I don't know. But yeah, aside from that, I'm just waiting on them to actually do something.
Well, I had some pretty big errors like that in the Tacoma Ridgefield lawsuit. When I first filed them, I filed for informal paupers as well. Then they said they sent me over a notice. I never got that notice in the mail. And then they dismissed the case. And I had to do a motion to vacate because I never received anything in the mail. And there's no indication that they can prove that I got it in the mail. So they reopened it and said, okay, we're going to send it over to you again. And, or you have until, I think it was like June the 28th or something like that to go ahead and pay the filing fee. So or July 24th. And I just went ahead and paid the filing fee. And now everything's moving forward in Ridgefield. So yeah, they tried to close out the case, but then I, said, nah, let me vacate this dismissal. And it got granted. And now we're moving forward with everything. But yeah, I just did over the, but wait a second. You know what? Let's do this. Everybody unmute real quick, and y'all say goodbye, world. On the public version of today's Operation Wise Dome.
Wow.
Peace.
Peace, y'all.
Bro.
See ya.